make a mention.
I recommend the item number 6 last time. After this letter, I will wait for India.
Have you informed the other side? Adjourned on the prayer of MSRDB and Council for intermediate. Take up with the court master whenever convenient.
12 September.
Yes. You want it adjourned? Your name, please. E. For whom will you appear? Item number 5. Dilip Das versus Body. I think it's Mr. Nair's matter. You wanted a journal. For whom do we appear? Petitioner.
Item 1 for motion.
Mr. Ganguly, just to give it are we first second Mr. Ganguly, just yes. Before the heat of point 27.
Regarding the quota,
so 17 it became consolidated for all the quotas.
And 17, what has happened is that the EWS quota, the economic sections, that came in effect from 17th of January 2019. And thereafter, from 2019 onward, I mean, at the time, we had 6 medical colleges. The quota was implemented, first of all, in Senate, and by the time last year, till 2022, the quota was implemented across 9 medical colleges. And now it is 12 medical colleges. Now the rule has been amended this year.
In 2023.
In 17th of July. It brought in the MRI quota, which has been announced later. And it imposed the cap on the EWS. Second, the 10% EWS cap will be restricted only to the 6. Let us say one of the established medical colleges.
To the additional 3 medical colleges, it will
not only the 3, but even the new 3. The new 3 medical colleges that
beyond the 6, it will not be applicable.
it will not be applicable. So,
is that your grievance?
So that is the grievance. For the purpose of this case, we are on the assumption that the rules are also valid and the MRI is also valid. We are not on those. What has happened is that selection list has come on 4th of August 2023. Now, in that selection list, what has happened is that the EWS quota, as per the latest amendment, should be 69 seats. Out of the total one is 1200 or seats, should be 69 seats across the 6 medical colleges, established medical colleges.
It should be 69 according to you.
According to them, it is admitted position. 69 is the quota at the state level. We don't know what will happen. The rules we assume it is valid. So the 69 out of 69 seats, 60 seats have been given in the improved selection list, the 4th of August 2023, which is the subject matter of this petition. And all the 60 candidates are over the last general category candidate. The marks. The last general category or UR candidate has got 552 out of 700. Whereas the last EWS candidate covered in the
last year I dealt with some CRPC matters where the OBC person, their cutoff was higher than the general. So ultimately, we are issuing directions that you consider them against a general. If I remember correctly, about a series of repetitions came. Yes, CRPF. Yeah, this thing happened. The OBC level was higher than the last of the general. So what order was passed is, so whosoever of the OBC, they were above the cutoff of the general, you give them the appointment as general. And that is it, OBC.
No, there is a different happen. This is regarding medical admission. There is a choice of college is given.
Okay, it's a
So slightly different. In recruitment manner, somehow they were there to get a post pilot written by.
so here there is a choice of medical.
Choice of preference of college.
So criteria is merit plus choice.
Yes. Now, we have the list from the technology, page 56. The selection list that we have changed. But the list actually starts in 57. So check the serial number 1 has got 690 marks. He is also from the EWS category, but on the basis of his merit level, he ended up being the highest rank candidate in the state. So he was rightly covered under the UR quota. He got his choice of seat in the party. So this is actually how the process should be done. Fair enough. We have no problem with that. So this is how the list progresses. There are several other EWS candidates at serial number
19.
Yes, sir. 13, 14, then again 19. So this is how the list progresses. 29, 31, 32, and so on. Now, if this goes on and lordship turns now to be.
Mr. Kandu, before you proceed, are you hearing the matter today? Are you finally hearing the matter today? We can hear. See, because after hearing for half an hour, I don't want to again assume that something more is to be done.
Page number 66 of the lordship itself. Serial number 220. Lordship sees this is serial number 220. The marks that this candidate has got are 594. He is also from the EWS category, and he is the first candidate who has been adjusted under the EWS. 594. He is from EWS, but he was not adjusted under the UR category. So in the order of merit, he has got 594, which is far higher than the last general category. Similarly,
No, what was the choice of this candidate?
the choice of this,
In a medical college choice, what was his choice?
it appears that his choice is Silchar.
Silchar. So, is there any UR of Silchar who is lower than 594?
Yes, there are.
Can you point out?
Well, as far as preference is concerned, I do not know. But
No, can you point out any Silchar preferred candidate UR but less than 594?
well, he is the first candidate as far as EWS is concerned.
We understand.
And the EWS list goes on. And finally, one of the finishes that was page number 75. The final EWS candidate has been adjusted. No, I'm sorry, it's at 76. Serial number 425. And 25 minutes. She has got minutes. 560. She is the last candidate who has been covered under the EWS. Thereafter, with anybody who has got in any other college, they are under EWS. So they may be EWS.
Jalan is Defo Medical College.
Yes, Jalan has got in one of the
Tezpur Medical College. And which are the 6 medical colleges you said? Guwahati, Silchar, Dibrugarh, Tezpur, Borbeta, and Jorhat. Possibly Jorhat. So these are the 6 colleges. Will be restricted to these 6.
So as a result of that, the 60, first of all, they are not given 60, they are given 60. And all the 60 candidates, because of the cutoff, because of the system, they are above the general line. And the reservation says that anybody in reserve category candidate, he has to be considered as a UR. Because if he is above the last general category, then he has to be considered as the general category. Only the option is open to
That principle, is it applied across all the reserved categories, or it is a principle in respect of scheduled caste and scheduled tribes?
all the vertical reservation. EWS is also a vertical reservation.
Do you have any proposition for that?
It is a vertical reservation.
Do you have any proposition for that?
Yes, I will come to the
That this proposition is applicable for all the reserved category people, or it is restricted only to scheduled caste and scheduled tribes?
Any vertically reserved, because that is similar horizontally reserved.
I understand.
The moment
Mr. Ganguly, we understand horizontal and vertical. We are asking you, the proposition you are relying on, it's restricted only to scheduled caste and scheduled tribes, or it is applied across all?
OBC also.
Do we have any proposition for that? Can you take it?
Specifically, when you look very judgment is there. 2018 to 66.560. So logic comes to the paragraph 8, page 662. Often in a competitive examination held for the purpose of admission in technical and medical institutions, some candidates run for reserved category or categories, qualify for the higher ranking on the basis of their own grade, and depending on their performance in the common entrance test are placed in the general merit list. Such class of candidates belonging to reserved categories who qualify on their own grade, placed in general merit list, are described for the purpose of convenience as meritorious reserved category (MRC). It is by now well settled that in MRC who goes on to occupy a general category seat is not counted against the quota reserved for a reserved category candidate, but is treated as an open competition candidate or general merit candidate. This quote in Indra Sani was in India has observed thus. It is in this connection is well to remember that the reservations under Article 16 do not operate like original reservation. It may well happen that some members belonging to stage and masters get selected in the open competition field on their basis of their own merit. They will not be counted against the quota reserved for general classes. They will be treated as open competition candidates. Even in service matters, the same principle is made applicable. The aforementioned principle of Indra Sani is followed for admission to seats in medical colleges, and the same was followed in R.K. Sabharwal of the state of Punjab. However, the issue before us is nuanced. When the MRC cannot for a seat earmarked for reserved category, the answer is yes. Hence, if MRC exercises the option of admission to the seats in different colleges earmarked for reserved category candidates, should a less meritorious reserved category candidate be affected by such process, be given admission to the college left over by MRC for unconsequent. This would be better if understood by a simplified example. If we assume that there are 100 seats available to one common entrance examination, PG courses in various medical colleges across the country. These 50 are general category seats and the 50 remaining are reserved category seats. X, the reserved category candidate is assigned 90 over 50 on account of his performance in the entrance examination. Thus, he is just above the cutoff for reserved category candidates and has got an open merit rank. Hence, X is an MRC. However, X being a general category is not willing to accept the seat available for general category at the time of his counsel. He wants admission in another college of his preference. Incidentally, reserved for reserved category candidates. And his seat
Okay.
the principal projects are relevant. Because now I would have to find out the rules. What the rules say. The rules are perhaps page 45. These are simply the latest amendment rules, the 17th July 2023. As far as the NRI thing is concerned, I'm not aware that if it's open December. As far as we are concerned, the right is because of page 54. Clause 5.2, which has been added.
5 point.
5.2 sections. 10% of the proposed state quota seats after deduction of NRI sponsored seats. They don't need Assam Medical College, Guwahati Medical College, Silchar, Jorhat, Dr. Area Medical College, and Kolkata, and 10% of the state quota seats. This petition, we have to assume that 69 seats are there for the EWS candidates. And if all the 60, as they have done, what they have done is that all the 60 candidates were above the last UR secretary, they placed everyone under the EWS. So what is the purpose of the EWS? The purpose of the EWS.
No, we understand. Can you show it us from the table how they have done it?
Yes.
You refer to serial number 228.
Yes. Serial number 220.
So he is the first of the EWS.
Yes. And we got
So
he's the person.
candidates over 220, they are placed as general.
No, he is one of the first one on the EWS who has been placed under the EWS.
That's what I'm saying.
Yes, he is the first. one.
The EWS over 220, they are placed as general.
Yes, over 220 and more. Because this starts at, and we should, as I've shown, starts at 220 and ends with Jalak Jalan at
No, what about serial number 1? He is also EWS.
yes, he is EWS.
So he is placed as UR.
He is given UR and he has got the college of his choice.
So number 1, EWS, but placed as UR on merit.
Yes.
220 onwards, EWS placed as EWR.
Yes, EWS places EWS. And this continues till Jalak Jalan, who got 568. And who is at serial number 425.
34 or 25 something.
425. She is the last candidate who has got the EWS student. She is 568. Now, the last candidate under the UR has got 552. And that candidate is at page 83, serial number 591. She has got 552 marks. She is EWS, but she has been adjusted under UR. And because she has been adjusted under UR,
And just So, Mr. Ganguly, you base your case between serial number 220 and 425. 435. Now, what Mr. Gugoi had said, that they determine the list on the basis of firstly merit, secondly quota, thirdly choice of institution. These are the three criteria they follow. Okay. Now, according to you, 220 Priyankar Day, he is the first EWS. And there are other unreserved candidates who got less than Priyankar Day had been placed in general. You are. And according to you, it cannot be. Okay. From the list, point out one candidate who had choose Silchar Medical College and is UR, but is placed before 220 Priyankar Day. Please point out one candidate. If you cannot point out, means the stand they are taking, we have to accept it, unless you challenge the criteria. No. Please point out the first candidate, you are in Silchar below Priyankar Day 220. But before this, please do this exercise first. Then you go to the next.
Yes. Number 64.
64. 64 is above 220.
Yes, about
Above 220, there will be many. Below 220. Mr. Gugoi, who is the highest EWS for Guwahati serial number? And highest for Dibrugarh, highest for Jorhat, highest for Borpeta, and highest for Tezpur. I think you need to work out it because if I have understood rightly, your case is persons less meritorious than a UR had been given admission as UR.
no, that is not it.
Mr. Ganguly,
As per the rules.
forget about the rules. Your case is Priyankar Day was given EWS, and there are other less meritorious than Priyankar Day UR who had been given. So therefore, the UR ought to have been brought down to some extent.
This is what the yes, what can be Priyankar Day is entitled to what he gets in honor of parents. He has got 500.
Then what is your challenge, please?
Our challenge is that the EWS quota will start when we finish. It is like this.
I understand.
When we
That would have been ideal had there been no choice of institute. Had the criteria of choice of institute not being there, it is only merit and UR, then you are right. But what they say, the criteria they follow is merit, UR, and institutional preference. So if the first EWS for Silchar is immediately below the last of the UR for Silchar, there is nothing wrong in their selection. It may be possible that for Borpeta, the UR may be lower, for Jorhat, UR may be lower, for Guwahati, the UR may be lower. But for Silchar, if Priyankar Day EWS is immediately before the last of the merit UR, then they have followed the criteria. This is what we are trying to ask you. So therefore, I wanted the information for Mr. Gugoi to test this criteria whether followed or not. Please point out all the highest ranking EWS for all the 6 medical colleges. If we find in respect of one medical college, a UR is lower than the first of the EWS, we'll correct it. We'll pass the order for correction. But first we have to work out that much. Which rule you were referring? Page number 208. Or else you have to challenge the rules. If the rules are arbitrary, you have to challenge the rules then. But as long as they 208. So which rule has been violated?
Rule 8C.
Rule 8. Rule 8C.
The second
Selection of candidates. During the counseling, candidates shall be called in order of merit and they shall pay their counseling fee. After scrutiny and verification of documents, if the candidate is not eligible, then the service shall allot a seat to the candidate in the previous course in the college according to the choice of the candidate. And subject to the availability of the seat in that particular college at that point of time before the selection.
I said the rule is in my favor. Second rule, provided that a reserved category candidate has in 5A-B-C in the schedule 3 of these groups entitled for selection on the basis of his or her grade, position in general or unreserved category, shall have the option of taking a seat in the college where a specified number of seats have been kept reserved for reserved categories, but while computing the percentage of reservation, he or she shall be deemed to have been admitted as a general unreserved category candidate and not as a reserved category candidate. So this is the first part of the program. So the answer as far as our submission, based on this rule and based on the learning and the episode followed by this rule, should have been admitted as a UR.
Why?
Because he occupies his place in the order of merit on the basis of his merit.
No. For Silchar, if I understood the state correctly, for Silchar, or after exhausting all the UR quota, he is the first EWS. So therefore, I am asking you one question right from the beginning. If you can point out one candidate in Silchar who is UR, but below Priyankar Day, then we accept your argument.
The list is not distribution wise. The list is a general list, and the distribution only comes in at the point of choice. That is why the rule is in 2 parts. There are 2 limitations here. Both these parts of the proviso, there are 2 limitations. First of all,
Perhaps we have not understood the proviso as we have understood. You please repeat your submission.
the first part of the proviso says that let us say Priyanka Dev, he has got 500 rank. He gets his position in the merit list.
See, let us look it from the point of view of Priyanka Day.
Okay.
Priyanka Day has given choice Silchar Medical College.
Yes.
He is also EWS.
Okay.
If all the UR seats of Silchar has been exhausted by candidates getting more than 594 what Priyanka Day had got, Priyanka Day cannot be given a seat on merit as UR in Silchar. If Priyanka Day is ready to move to some other medical college, case may be different. But that is the choice of Priyanka Day.
No, if he gets in any other medical college,
Then how can
he
you?
will not get as a EWS. Because,
No,
there
he'll
are
get
no
as a
seats in
merit.
the others.
So this is what we are saying. Now, the authorities and the rules have been provided for three different criteria. One, merit. Two, reservation. Three, choice of institution. And all the three will be equal components to determine the resultant merit position. Now, if Priyanka Dey can be convinced to go to some other medical college, or he voluntarily goes and they agree, then he'll be unreserved. Because that medical college, the UR cutoff may be less than 594. But in Silchar, the UR cutoff for is above 594. So Priyanka Dey can not be offered the seat as a UR. This is what we have understood till now. Now please explain. Now what is your argument?
My
Please?
argument is that first of all, what does it say? Provided that a reserved category candidate has in so on the schedule 3 of these rules, entitled for selection on the basis of his or her merit position in general or unreserved category.
So provided that a reserve candidate
Candidate
entitled for selection,
on the basis of his or her merit.
merit position. So Priyanka Dey is he entitled to selection on merit position?
If the institution comes, then maybe no. But
Then how can you remove the institution?
it is like that is what I'm saying.
Does the rule provide that institution should not be taken into
His
consideration?
choice, his choice does not render one seat of the EWS occupied. It does not mean that Priyanka Dey has to be put under the EWS. He has to be deemed to be a reserved, a general category candidate. Only from the purpose of the choice, he gets
Deemed to be
deemed. There are two legal fictions.
legal fiction. Where is the legal fiction?
So here it is. While computing the percentage of reservation, he or she
Where are you reading?
well, I'm reading about after this part, entitled for selection on the basis of his or her merit position in general or UR category. Shall have the option of taking a
Shall have the option of taking a seat in the
in
college.
the college, where a specified number of seats have been kept
Kept
reserved for
reserved.
reserved category. But while computing the percentage of reservation, he shall be deemed to have been admitted as a general or UR category candidate and not as a reserved category.
Just a minute. Shall have the option of taking a seat in the college where a specified number of seats have been kept reserved.
Yes, because Silchar has the EWS quota.
Just a minute. What does it mean? Provided that a reserved category candidate in Schedule 3 entitled for selection on the basis of merit position. So first you have to qualify this part, that the person is a reserved category candidate and he is entitled to selection on the basis of merit. That is what is called MRC.
MRC.
So you have to first show that you are a MRC. Is Priyanka Dey a MRC
Yes. Priyanka Dey is an MRC.
for Silchar?
No, I'm breaking.
No, just
So the rule is 2 parts.
no. To every part. Is Priyanka Dey a MRC for Silchar?
But Silchar option will come in the second. But first of all, the list is not institution wise. The list, the institution choice comes at the second step.
Okay, what is the
First
second?
of all, he has to take, Supreme Court says that the list has to be first in order of merit. Now, in order of merit, irrespective of the institution choice, Priyanka Dey is at serial number 220, he has a specific state rank. That rank does not depend on his category. The question of category comes in because he must have given what happens generally that all the candidates, first of all, they generally, let us say, give the first choice as Guwahati Medical. Then we do that so on and so forth. Now, assuming that Priyanka Dey does not get a seat in Guwahati Medical College, because other EWS candidates have already got. But we find that the person who got the first rank from the state, he got in Guwahati Medical. And he was adjusted as a EWO. Because
Because he is MRC.
he is MRC. He is MRC, but he has been adjusted as EWO. Our What is it that they also, irrespective of the
So now the next question, what you are arguing is from the list point of one MRC, who is not adjusted against the merit in that college, in the college of choice.
yeah, college is not questionable. College comes in second. Because for the purpose of deeming, he has to be deemed. That is what the rule says. He shall be deemed by the admitted as a general category. So he has to be deemed as you are. But for the choice, he will get censure, no difficulty. But he cannot be treated as a major person. The lesser meritorious candidate after deeming. This is what has been done. All the 60 candidates on the list, irrespective of the question of institutional choice, they may have made or may not get.
Can I note down your submission? Just repeat your submission. Please slowly repeat your submission so that I can put it.
The purpose.
According to you, the proviso has two parts. First part, there has to be mandatorily a list on the basis of merit, irrespective of the institution choice. Institution choice comes at a later stage. And this is, and according to you, the impugned list is a list of the first part, or it's a list of the first and second part combined. Combined.
Question of institution comes in only when the counseling stage.
So this is a list after counseling.
This is a list after counseling. So in order of training,
See, when the Mr. Gogoi, when the authorities had called these candidates for counseling, I think you had a list entirely on merit.
Yes.
According to the merit list, you kept on calling.
Yes.
So that is there. Now, this list is a list resultant of the combined effect of the two parts of the proviso. When the second part of the proviso will come in, the institutional choice will also have its own role. And after giving effect to both the parts, this is the resultant list where Priyanka Day 220, 594 marks is the first of the EWS. And he is immediately after the last of the UR for Silchar.
No problem. He can get censure, no difficulty. The point is that he cannot be treated as an EWS under the EWS quota. He has to be deemed to be a general category. That is what the rule says. That is what the Supreme Court said.
Yes, Mr. Nair, can I help you as a amicus? I'm having difficulty in understanding. I think you are participants reservation.
Shall have the option of taking a seat in college where the specified number of seats have been kept in the college category. But while computing the percentage of reservation, she shall be deemed to have been admitted as a general unreserved category.
So this is the concept of MRC, what is referred in the Supreme Court judgment. Right? After that,
shall be considered to be respective categories of that particular category.
one thing I have not understood of Mr. Ganguly's argument, if Priyanka D is now declared to be on merit as UR, that declaration will result in a situation where we will exceed the quota fixed for UR. Because he will be beyond the UR quota because last of the UR quota is already filled up. If effect of the declaration being sought for, can we do it?
What I have understood is one, you come on merit. In merit, he may not be getting a choice of the
See, Priyanka Day had the choice at the counseling that I forego my choice of Silchar. Let me go to Borpeta, but I want to be on merit and not on any quota. He had that option. But he opted that I want only Silchar because that is my choice. Silchar, last of the UR had already been filled up. Quota is over. So now where will, under the law, under this legal fiction claim, will he be UR or he will be EWS?
That's one of normally complete seat. Normally, if you say a UR seat is one, that would be a reserve seat. Normally, because you have opted and you have gone there. But here I think there is a catch.
What is the catch?
My lord, provided that the reserve category candidate in so in schedule 3 of this rules entitled for selection on the basis of his or merit in general unreserved category. So my lord, this is irrespective of any reservation. Any person who is on his
Any general category candidate?
it will be all.
No.
Provided
Provided
that
the reserve category candidate.
Watch.
Provided
In the
a
schedule
reserve category candidate
entitled for selection on the basis of his
merit shall have the option of taking a seat in the college
where a specified number of seats have been kept reserved for reserve category. So, my lord, provided that the reserve category candidate in the schedule of these rules entitled for selection on the basis of her merit, position in general unreserved. We'll just stop here. Reserve category candidate, because of her merit, she is now entitled for getting a post, a seat in the general category.
provided the person is entitled for a general category.
Madam, here,
Once the general category is exhausted,
Madam, that's what I'm trying.
this provision has no further
I
effect.
may be wrong. Just, my lord, just allows me to go further.
Yes, please.
Shall have the option of taking a seat in the college where the specified number of seats have been kept reserved for reserve category. So, my lord, what I've understood here, that the reserve category candidate who is there on merits entitled for appoint a seat in a general or unreserved category will be given an option of opting for a college wherein the category to which he belongs, a post is reserved. Now, but while computing the percentage of reservation, she shall be deemed to have been admitted as a general unreserved category candidate and not as a reserved category candidate. Now, what is the effect? Under such circumstances, one seat of unreserved category of another college of his or next preference shall be converted to the respective category of that particular candidate to maintain the total number of reserved categories.
So, is it your suggestion that Priyankar Day,
Not
now he will be made a merit candidate, and as because one UR quota will be consumed in doing so, one quota of Borpeta will be taken away, and the Borpeta UR will be converted to a reserve. Is it your submission?
My lord, if
I
this
think-
is more subject to my lord, I've seen it for the perspective. So this, if I read it in a whole, that is, it's an anomalous
No.
situation.
Suppose we accept that submission, that interpretation, Mr. Nair,
Lordship,
will it not lead to absurdity?
it should.
And there is an interpretation principle that any interpretation which leads to absurdity should be avoided. It doesn't make any sense. Suppose now Priyanka Day, for some reason, he is entitled as EWS. Now he goes and makes a claim that by this deeming provision, put me on merit in Silchar. So Silchar will have one seat more on UR. So in lieu of that, what you do? Borpeta will sacrifice one UR seat, and that will be converted to reserve. I think this is lead to absurdity. And why should the Borpeta UR man suffer? Because of Priyanka Day's choice? There will be one UR.
Mr. Day,
There will be, if this is accepted, there will be one UR in Borpeta also. Last of the UR, his seat will go for this adjustment. So one UR merit for Borpeta will be ousted because one Priyankar Day deemed it appropriate that I want to invoke a deeming provision, put me on merit. Although he is not entitled on merit.
this whole thing can be clarified, subject to what if my friend can bring up an instruction that whether the reservation per se is calculated on the total merit list or the reservation is
No,
institution based.
see what they have done. Moment the choice of institution criteria also came in. First, Mr. Nair, what they have done is, if I'm wrong, please correct it. First, they take out one whole merit list on the basis of performance. Forget about reserved, forget about unreserved and everything. Okay. After that, they have fixed number of seats in the 6 medical colleges. This is the second part. Third part is, suppose X medical college has 100 seats. Then they put in the reservation. 50% will be UR, and whatever is the division, whichever you do it, they will do it. Okay. Once this is done, then they find out for that medical college how many seats are there for UR. Now you have one whole merit list with you from first to bottom. Out of that merit list, people have given choice of institutions also. Suppose there are 40 UR seats in Silchar. First of the 40 UR from that merit list opting for Silchar will be fitted in. Once the 40 seats are over, the 41st seats come in, it is no longer available for UR. Next comes is from that merit list, the first man who opted Silchar belongs to EWS. This happens to be 220 Priyankar Day. Now, if we give this kind of an interpretation as thought to be given, and now make Priyanka Day an unreserved candidate, that means Silchar will have 41 UR, although you are entitled to only 40 UR. If you further understood what you have submitted, you take out one, you will have to take out one UR for Borpeta because the overall balance has to be maintained. So now, because Priyanka Day, who otherwise also got a seats, wants to make a claim by invoking this kind of an interpretation of a deeming clause that I want to become a UR. So make me UR, because otherwise I'm on merit there. Last of the UR of Borpeta will have to sacrifice his seat, because that will be now made a reserved category seat in lieu of this 41st seat of Silchar. The last UR of Borpeta will become a reserve now. Why should that candidate suffer? That's why we repeatedly ask the question: if there is a single UR candidate in Silchar below 220, please point out. We'll correct it immediately.
Subject to what, my lord? Something came into my mind and just I was. My lord, when they fill up the universities, all over this state, there is one cutoff. It's not a cutoff mark for Dibrugarh, Borpeta, or something. It's not like that. There is one cutoff. I'm just coming. The cutoff mark would be, say, my lord, 550. I'm just saying.
Mr. Nair, the procedure they are adopting, the procedure they are adopting, it appears it's a
Fix.
variable cutoff mark at different stages. It's not a fixed cutoff mark. First cutoff mark is the merit list, the last man who gets it. Is the cutoff.
But I'm just pointing that out.
Next cutoff comes.
So I'm only pointing that out. One of the state, whoever it is, he has five.
And who is a client, Mr. Ganguly, or on whose behalf he is causing the cause? He got 540 and he is a general category. EWS general. If now this day becomes general,
Not only they and
all those, they become general,
Yes.
they will be entitled under EWS. This is your
That is his case. Also come in. I'm telling why this. Say they, Mala did not go to why this provides so how we can understand. A person Mala on merits that till that cutoff mark of 550, he can be appointed. He can
anyway.
So Mala, there should be 550 Mala general category candidates. Or Mala say let's hold it Mala 550 cut-off mark 550 seats, general seats. This can be anywhere. There has to be 550 UR seats all over the state. In all of the
Mr. Nair,
What I'm trying
no,
to
no,
point out.
I think you are right. And we put that question to him.
Then
Go
what
ahead.
happens, my lord?
If they,
Lordship?
for some reason, says, I want to forego Silchar,
He'll be there somewhere else in a merit
he
position.
somewhere he'll be there on merit.
That is why, my lord, they are saying that the post, if he is adjusted here, he will be a merit candidate here on merit. But the other post where he could have otherwise gone, that would be converted to a, my lord, the category he belongs to. Now, my lord, with that thought, if I can just remain, provided that.
So again now,
Lordship.
Mr. Ganguly's client will not be benefited. The one EWS in Borpeta will be benefited.
But no, it won't be that. It would be the.
So how can the Silchar preferred candidate now go to Borpeta then?
My lord, how they have to do it is, one should say, my lord, there is a list of 1,000. Say list of 1,000. 1 to 500 will be general of 550. One to, my lord, 551 would be general. Come on, put a line there. In this 151, I'm just trying to understand the second provision. 151, they will have, my lord, 551 posts all over the state. One of them, my lord, say 551, he is getting more better, but he wants more. So he says, I am a EWS, there is a there, you consider me there. This provision. They will consider him in Guwahati, but
How?
that's what they are saying here.
No, please repeat what you said. Just.
My lord, cut off of 551, 1,000 seats.
551 cut off for what?
My lord, general,
General.
50%, let's say.
General.
Gone. So, my lord, everybody is like.
So number 551 now comes up.
Now, 551 comes up.
Then what he says?
Gets, my lord, say Borpeta, on merit, you are. Borpeta, he gets it. But he says he opts for body medical.
Under
His first
EWS.
option is body medical.
Under EWS.
He's opted for, let's say not EWS, but his option is this one.
This option, at what stage you call for the option?
Options are there of submission of the application form itself.
So that time itself you determine your right.
Right, madam. So then, my lord, this would come. This provides it. I can read it. in that
Understand?
line.
So a man who had given the option of Silchar or given the option of Guwahati at the stage of finding the application itself, that also must have some credibility, some meaning to it.
So, my lord, if he gets it in his merit position,
I think
after they-
what you are submitting will become a mess.
I don't think so.
It will become a mess.
Because then this thing will fall in place.
Understand?
All this thing has to be.
See,
held
the
back.
interpretation even Mr. Ganguly is trying to give is an extreme
My
interpretation.
lord, this is just, my lord, whatever deliberation. From there I have.
It's an extreme interpretation. Possible to interpret that way, but the resultant thereof will be tomorrow. You see, there are 1,000 candidates. All thousands will be claiming crisscross everywhere.
Why not can have this matter
So-
at 2 o'clock. My friend can get an instruction from the authorities, how they do it. That will matter because now we are all in.
No, I understand. The examples you are giving is one example.
Lordship.
Now let us convert that one example into 500 examples, because 500 people will be entitled to do that, what you are saying.
Lordship.
Once 500 people make this kind of a claim, and that 500 will affect another, I don't know how many.
My lord,
So who is going to
it will
sort
not
out that
affect, it
mess?
will not affect. The effect would be
And ultimately,
22%.
and,
That means
no, and,
20%.
and ultimately, you see, we want doctors.
Lordship.
Purpose is to have doctors, some good doctors.
And for this purpose, whether the doctor is
So-
EWS in my lord, Borpeta or.
Doesn't matter.
Doesn't matter.
So, in making this calculation, the amount of time we will have, we may not have doctors for the next 1 year.
Minority,
This litigation is ongoing.
it's not required, my lord, because this choice
Mhm.
will only come within that 551.
It's a-
It will not be more than that.
Yes, sir. What do you say, Mr. Guru?
The last part of it provides a clear
Hmm. How do you understand your own rules?
I say that by the state results in the
And this has been in existence for 2017.
and it is followed in every category. And is that
No, till up to 2023, what was the procedure followed? The same one.
Yes.
That is not under challenge.
No, right. But here what happens is
Because how do you understand the provider?
same manner EWS category candidate. Because of this higher rank manner, if you at the time of counseling, you fall for the unreserved category seats at the time of counseling because it's higher in rank.
So he has the option to give orbital choice.
Yes, same manner his choice of college is GMCS, first choice. Second is AMCS, third is teacher medical college. Now, manner, while his name will be called for counseling under the unreserved category, though he is a EWS candidate because of his higher rank. At the time of counseling, when manner the authority will consider his preference. By that time, supposing him manner the seats under unreserved category in GMCS is already filled up. Then he will have the option to opt for the EWS
In GMC.
in GMC. If that is available, then that seat will be given to him.
As EWC. As EWS
But he will be considered as an unreserved category candidate.
That's
And
For-
not once,
for in GMC.
yes, in GMC.
If you do that,
No, my lord,
will you not exceed quota in
no,
GMC?
that's why I'm saying, my lord. In that case, my lord, one seat, third choice is my lord, Silchar Medical College. As per the rule I'm saying, my lord. In Silchar Medical College, one EWS seat will be converted to unreserved. So that my lord, 50% is maintained. This is the procedure we are following.
One
seat
EWS
will be
of,
considered to general, unreserved.
so just a minute. So
Unreserved will, EWS will be converted to general. Last line may
no, one EWS in
in Silchar,
Silchar will be converted to
general. Sorry, madam. One general seat will be converted to EWS.
Yes.
one general seat will be converted to EWS in Silchar.
Yes.
One general seat will be converted to in Silchar.
Yes.
So now, suppose we declare this day 220 to be UR by following the same principle. Now, in which place there will be an addition of one EWS?
Madam, it's the second choice of college.
What is the second choice of college of day?
That madam is not there in the chart. In his application.
So anyway,
Madam,
one EWS will increase in
in his next choice of college.
in his next
maybe
choice
madam,
of college.
If it is Silchar, it may be madam, Jorhat.
Suppose it is Zohar. So one EWS will increase in Zohar. And who will get that increased seat in Zohar? EWS.
Madam, on merit madam, it will be called madam at the time of madam filling out the.
So then you have
50% is
to,
maintained, madam.
in that case, you have to redo the entire select list. No,
That's already done as per the rules.
no. What Mr. Ganguly is submitting, if now day is converted to UR, okay,
In case of this madam, it has not been converted. These are EWS candidates, he has been allotted as. Lordship, may kindly see the chart for a moment. One thing I have to point out. Page 66, just how the conversion will be. Page 57 is started. Lordship will see the first candidate in the EWS. He has been given unreserved.
why do you make the rules like this? Every year there will be litigation after
Well,
litigation.
in the textbook, that will also, this has been this particular conversion.
This conversion, okay.
Lordship will see madam.
Page
57
66,
No, 57 is started.
uh,
Lordship may see madam, page 60.
60,
Page 60.
60.
Because in page 58 and 59, all the EWS candidates, they put their source of college, so they were admitted and unreserved in their source of college in GMC. That was maybe the first source of college. About page 60,
60 years.
serial 73. Not you will see my love, EWS. Yes,
73
category EWS.
EWS category.
EWS.
So now he is appointed as given as EWS in Guwahati.
Yes, but though he is EWS, it will be considered as UR, unreserved. Now, an unreserved seat will be converted to EWS.
Where?
Not-
101.
Yes,
That 101.
101.
Serial number 101 is converted now.
May I not give this code? 101 is AMCS, 103 is GMC.
Okay, this is 4.
Code. So what you will see the code GMC is 102. So one seat, unreserved seat in AMCS will be converted to EWS.
1 seat in
101 is AMCS.
1 unreserved in AMC will be converted to EWS.
So that 50% is maintained.
Okay, now who will get that EWS in?
According to my at the time when the counseling is here, anybody will got the choice of college as per his merit time in EWS or is saying unreserved education.
So now how do you deal with these repetitioners now?
Well, considering that they was higher than they would have been considered under this procedure only. So you will have to see whether their candidates were above you.
So now,
Just
just a minute. Upon this 220 being EWS, but converted to UR, there will be correspondingly 1 EWS in some other college other than Silchar. Which college? No, you have to give us this information now. And in that EW that has been newly created because of this conversion, whether the repetitioners will be entitled, that will examine it. If they are entitled, they have a right. If they are not entitled, they do not have a right.
So far as the we have already pointed out, though this time is where the medical college, the admissions have been given, but EWS is limited to 6 only.
6. So they cannot claim beyond 6.
So
They are not claiming also.
not on that point. Now, after
So,
let me one thing. After filling up this EWS 6 medical colleges, the otherwise EWS candidates who are higher in rank than the petitioner, but they do not have a seat in the other EWS quota in these 6 medical colleges, they have, as per their merit rank, they have been considered as unreserved in the unreserved categories.
in some other medical
Yes,
college.
even they do not qualify in that category, man. They are down below. Beyond, above, man, of this
No,
petitioner.
no. So, let us pass an order that 1 either by 220 Priyanka Day being deemed to be a UR, although EWS, correspondingly another UR in some other medical college was converted to EWS. You identify which one.
Now, in case of Priyanka, there is no conversion. EWS, yes, what a EWS. He is seeking the conversion.
No, but they are seeking the conversion because they are entitled to conversion. That is his case. His case is under the rules, we are entitled to a conversion. Once the conversion takes place, which will be the corresponding EWS otherwise, and then we'll examine whether the petitioners will be entitled to that EWS.
Why is 594? She has been considered as EWS and then started as EWS instead of considering her as a EWS. So conversion will come only when she will otherwise be entitled for a seat under keyword. But she
No, but the 594 is higher than many of the URs of the Tezpur and Borpeta. That we have noticed.
Yes, that part of I was.
So- So, as we understood initially, you have followed that procedure.
Yes.
And what we understood subsequently, you have not followed that procedure. It appears.
That's what I
Exactly that. What is that German thing, madam? What is the basis? If they place that, because I find here, madam, if your lordship can have page 66, there is, madam, a candidate who is a SC, but in merit, she has got 595. She was, madam, that seat was converted to UR in coordinator. SC post. She was an SC. That post was considered as a UR,
Where was she admitted?
Guwahati Medical College.
Guwahati Medical
So
College.
that SC post got adjusted somewhere else. If that so if that principle is applied, this has to go on for all.
Everybody.
Then,
That's
okay,
why
then this rule will proviso will have
it's,
some.
Togo, now we are having an apprehension, maybe that to reboot the entire district
Well,
affairs.
super is 220, of course, madam. I have also thought, but down below in the next page, there is
So
conversion.
why don't you do one thing?
I will
You produce the complete records of the conversions.
Along with the basis. Of the,
Not only for one or two officers who are converting in this manner, that procedure, they will take that.
Let them also be here because they will be knowing the value want it to be taken up.
If you put around
Because medical admission has to be, we have to hurry up.
Friday, madam,
Other than Friday.
holiday.
The classes will start.
I know. So therefore, and after a particular date, Supreme Court says you can't do it anymore.
30th of September.
30 September is also not very far away.
No, I understand.
But the Supreme Court has stayed the NRI part of the.
That is not,
That also we are.
NRI is not the.
That we don't want to mix up all issues.
And madam, it will be
We don't want to mix up the issues, but now if we accept this one, that a person on merit in a given choice of institution is beyond the stipulated UR, gets into EWS, invokes the proviso, making it deemed that he is UR. Correspondingly, there will be one UR converted to US in some other medical college. Number one, which medical college, if this deeming provision is invoked, in which medical college you will convert one UR to EWS, and who will be entitled to that one, whether it is the petitioner.
Or anybody else. But whether an EWS candidate will come, that's what they are.
Considering the rank manner of whether it's given a
This is
Again,
again,
the issue with whether it's
I don't know. Why did you put in this conversion thing? This will complicate the matter like anything. Today it is one person who has come, tomorrow hundreds will come.
Supreme Court has said that.
Hmm.
So,
Where is it said? Supreme Court, let us see what Supreme Court said. In which aspect?
So that
That Tribunal Sharan, that one.
Para 10 is very clear.
Para 10.
Para 10.
there are 26.1 and 26.2 is that. Page 670. Page 670. An MRC can opt for
With 20.
page 26.1. An MRC can opt for a seat earmarked for reserve category so as to not disadvantage it against less territorial reserve category candidate. Such MRC shall be treated as part of the general category. Due to the MRC's choice, one reserve category post is occupied and one seat amongst the choices available to general category candidate remains unoccupied. Consequently, one lesser ranked reserve category candidate who had choices among the so and so is affected as he does not get any choice anymore. To remedy the situation, to provide the affected candidate a remedy, the 50th seat which would have been allotted to X MRC, had he not opted for a seat for the reserve category to which he belongs, shall now be filled up by that candidate in the reserve category list who stands to lose out by the choice of the MRC. This leaves the percentage of reservation at 50%.
So now, this Silchar left out EWS will have a choice in some other of the 5 medical colleges where one UR will be converted to
Why in this particular case of serial number 220 being in higher rank, he has been considered as EWS and when along with the seat of that EWS without any conversion.
in which one? Here. No, but
There should have been some conversion.
there ought to have been conversion. This is a difficulty.
That I will have to clarification.
So now, once you convert, what will be the result of the conversion?
We'll have to see whether how in which what are the preferred colleges. Say whether if it is first preference is intermediate.
So one UR of some other medical college will be out.
Yes. No, not out. Minus one seat will have to be converted.
No.
Already a seat has been allotted here.
Now when it is converted, one UR will be out.
And yes.
One UR will be out, and one EWS will be in.
It will be of course the last one.
Because of the wrong calculation, maybe they have already allotted that yours to somebody.
No,
Maybe.
let me bear the justification why it has been done. But okay.
When you want the matter to be taken up, let it have it on Thursday. Because otherwise, the time will be little less. Third, Mr. E. Ganguly, Learned Counsel of Petition. We also requested the assistance of Mr. E. K. Nair, Learned Senior Counsel, to interpret the second proviso of the Rule 8C of the Medical Colleges and Dental Colleges of Assam Regulation of Admission into First Year MBBS from BDS Course Rules 2017. A reading of the rules makes it discernible that if EWS candidate on the basis of his merit is otherwise not entitled to a UR seat and is offered a seat as a EWS candidate under the deeming provision of the second proviso, he would be entitled to have his offered seat to be considered on merit. Now, Mr. Ganguly, this is a choice of the candidates or it is mandatorily they have to do it? Understand? No. This conversion is a mandatory requirement or it is a choice of the candidate?
Conversion of the seat. First one to the choice.
No. Did Priyanka they ever wanted to have it converted to a merit? I think it's a choice of the candidate.
But even otherwise would be entitled, even at the time.
No. And if you read paragraph 26.1 of the Supreme Court, so first read with para 10. Hence, X is an MRC, okay? Somewhere in the middle, press it on C. Hence, X is an MRC. However, X being in general category will not be willing to the seat available for general category at the time of his counseling. Okay, till now no choice has come. Generally, there are some EWR seats. Counseling, he is offered a UR seat that you go to X institute. He wants admission in another college. So the choice of the candidate, he wants it in Y college. Then what will happen, which is incidentally reserved for a reserved category candidate. A seat in the same is available in the reserve. Consequently, X chooses a seat available in the college meant for reserved category. So instead of accepting the offered UR seat wherever the authorities offer, X feels that I want that specified institute, which is otherwise the reserve. He'll be entitled. As he does so, one seat in the general list of 50 candidates remains unoccupied because he had foregone his there. On the other hand, occupied one reserved somewhere else. In that context, two questions arise: whether X MRC can opt for a seat for a reserve. Answer if yes, so and so. Now what happens? Happens is para 26.1. And MRC can opt for a seat earmarked for the reserved category so as not to disadvantage him against less meritorious reserved category. Such MRC will be treated as a part of general category.
After making the choice.
And now, no, after opting for change of institute. Now, this person has not opted for any change of institute. This serial number 220, right from the stage of submitting his application, his choice is Silchar. Had it been such that in Silchar he did not make it out in the EWS, okay. Now, in the no, this person in Borpeta is offered a UR. Fine. Borpeta man wants to come to Silchar. Then he makes a conversion to Silchar. That Silchar EWS, please give it to me because on merit, I'm entitled in Borpeta, but I would prefer Silchar. Silchar, one EWS is occupied by the Borpeta man. Then the deeming provision will come. The post where he was given in Silchar will now be converted to a general. And correspondingly, one post in Borpeta general will be converted to EWS. In that case, I think this example of this rules is but your case is from the reverse direction. So, understand? See, we are still in the stage of deliberating. It's not that any conclusion has been arrived at.
What happens is that the corrections are made.
So, understand. So now, this entire exercise of conversion, etc., whether you go by the judgment of the Supreme Court or you go by the rules as sought to be interpreted, one condition precedent is the candidate himself chooses to go somewhere else. So that's a voluntary choice of the candidate. Can that choice be imposed by others? And so now the case you are making out, these unsuccessful candidates are now trying to impose this choice on this man so as to bring in. You think about it. We'll hear you later. We are passing the order, but you also have to think about this aspect. At whose instance it can be done. So in this case, whether there will be a conversion or not, as long as they does not gives a choice of conversion.
The choice can only be made by the meritorious MRC in this case, only 6 medical colleges when seats are. If there are no seats, or if he chooses, let us say, premium, then he will not be treated as such. Because there is no risk.
That it has to be, it's confined to 6 only.
Reading of the rules with this level that EWS will be there on the basis of this merit is otherwise not entitled to a UR seat and his performance seat as EWS will be there under the provision of the second provision. He will be entitled to have his preferred seat to be considered one minute.
Or to be considered to be a UR seat. Correspondingly, one UR seat in some other medical college would now have to be converted to a EWS reserved seat. The respondents to produce the records of the allotment and conversion, if any, to understand the aforesaid proposition as being presented. This is good.
See number 20.
For this 20 minute, that may be different.
Sorry,
And just with the serial number.
between two serial number 220 and 545. 425. Think about it, because it's not a very easy answer. Other example is very easy. The Supreme Court example that is very clear. One man, he gets UR in X institute. Till then, that stage choice is not there. At the time of counseling, he says, "I want another institute." There, the choice comes in. And that institute, UR is not available, but he is also reserved. So he says, "Give me that reserved post." But as he was entitled as UR in the first institute where he was offered, that reserve post will be converted to UR under this provision. And correspondingly, the original institute where he was offered, one UR will be converted to reserve to maintain the balance. When two institutes are involved in respect of a candidate, it's a very easy answer. In which college the conversion will take place? The college where he was originally offered the seat. Here is a case, there is only one college. So correspondingly, in which college the conversion will take place? Choices now, 5 remaining colleges. So next question. Yes.
He would also sort of discuss the rule. The rule has been, let us say, not very happily crafted. What has happened is that the choice for making the choice, the MRC has to choose a seat in one of the 6 institutions. But there is a pre-existing seat from there is a reserve seat. Partly, etc. He cannot make a choice. Let us say one of the creator belongs to Hubli. He cannot say that I will go to Hubli. If he is not, because he's getting on.
No, I understand. The entire thing would have been very clear had they been offered the UR seat, say in Borpeta. Okay. They says, "I want to avail the EWS in Silchar." And accordingly comes in. Then invokes the proviso, deeming provision. So now make the EWS in Silchar to be UR. Correspondingly, the seat where he was originally offered, that is Borpeta, one UR will be converted to EWS.
Yes.
If you go by the Supreme Court.
But if there are no UR seats in, let us say, Bermuda,
So now, so their conversion would have been in Borpeta. Now, as the preceding circumstance is not present in this matter, he is straight away offered EWS in Silchar. Now, out of the 5 balanced medical colleges, in which one will you take the conversion?
in the next preference that is what the rule says.
Next preference. What is the next preference of this
So
one?
that will be removed from the report.
Region of 20 or 220, but I have transferred from the petitioner. Here,
Mr. Nair, I think we'll have to hear you a little more also.
This is something very different. I think
Something
You also get it clarified.
So there is no convert.
The example in the Supreme Court is MRC is offered UR in X institute. Okay. He exercises the choice of institute. Say I want Y institute, where only reserve category is available. He occupies the reserve, and in Y institute, he is deemed to be a UR. Correspondingly, one UR in X is now converted to reserve. Because situation is very easy before, in the example before the Supreme Court, because two institutes are involved straight away. Here, had they been offered a seat in Borpeta, and they says, I want to go to avail the Silchar EWS, avails it, then invokes the conversion proposition and says, now make it UR. Correspondingly, Borpeta UR will become EWS. But here is a case, there is only one institute. He is offered EWS in, he chosen for Silchar. He had offered one EWS in Silchar, he had accepted it. Where is the change to come into? We'll hear you on the next day. You please apply on my notice.
Information for that would be required. Because when they prepare the seat matrix and the list for counseling, they have already allotted seats, hypothetically, to candidates first. That exercise they do it. And thereafter the counseling, we go and we
Was they offered any seat, your seat in any other
it
institute?
might have been allotted in the
Find out that.
that instruction.
Once you have it, then we can fit in with the Supreme Court proposition. Otherwise, you can't.
I don't have it on Thursday when I like this.
No, then the next question it will be, out of the balance 5 institute, in which institute conversion will take place?
That will become
Mr. Ganguly made his submission on my second choice.
this.
Whose second choice?
MRC second.
Okay, that's it. That's the MRC's second choice.
We have two choices.
One seat of artisan category of another college of Ishwar her next preference shall be converted. Next preference. So if
So the MRC's this next preference will be
second
converted.
preference has been given. So third preference will be converted.
And this
So
exercise
if
is
third
done.
preference has been given, then second will be converted. Next.
So now days what we have to find out what is day's second preference and whether conversion took place there or not.
Well, it has not been converted from this particular document, but I will have the.
I think you have to do it otherwise.
That's an apparent.
And my lord, wherever the meritorious candidates have been accommodated by giving EWS or reserve or something, all those places, my lord, like they'll have to carry the excess.
That is what we are.
That they'll have to carry.
Then I think we have to redo the entire thing. It appears.
My lord, it will satisfy your lordship, my lord, whether there is something and then
And
my lord
only
can
for
direct.
one seat, otherwise.
Hmm.
So it will be only for one seat. So far as this would be this concern.
But moment we pass the order, another 100 petitions will come
So
up.
they have to, my lord, take that also, my lord, they have to pass that order also.
So let me have the clarification. If there is a justification.
No, no.
then it is tender with the-
Suppose you have done it rightly, then no difficulty. We'll close this one. In the event it was not done rightly, then what will happen?
And my lord,
Then wrongly must have been,
recasting will-
wrongly will be across the board, not just one candidate.
But the beauty here is, my lord, whoever has got it under UR. So, my lord, there may not be much, because they otherwise, my lord, merit they are there. But the problem would come if some SC candidates, my lord, have got it. Then, my lord, that UR may have to go. There might be a change. My lord, we'll have to see.
You don't know how many people will be involved.
They have to have that instruction. Okay.
First conclusion is we have done it right.
No, fine.
Then no
That
difficulty.
presumption is there.
Second conclusion, suppose we are wrongly done. the requirement of the rules had not been followed exactly. Better you hurry up, because otherwise your 30 September is the last day. You should have time to.
I don't have it. First day my friend can have those.
Personally indicate whether that I would be whether they would have the assistance of some official. That it may be recorded
As a detailed understanding of the procedure undertaken would have to be understood, comma, officer of the department conversant with the allotment of seats and the conversion, if any, may also remain personally present before the court.
And the process might not have an indication.
I think we are already past it.
These are the beauty.
This Thursday.
Manoj, it's on Thursday.
Thursday.
I also agree.
No, what you have submitted, I think is consistent with what the Supreme Court had provided.
I'll put to that.
Mr. Nair, this EWS is held to be vertical.
It's held to be vertical, so that conversion is possible. That a person will be having 4 months.
No. Ultimately, how is it justified? Vertical.
One of the, I think there's a judgment of the Supreme
No,
Court.
I know because last year medical matters I
Manoj,
did.
so that exactly, Manoj, I only know that it has been there. I did not have an
And
opportunity to examine.
how the 50% is dealt with?
But they say, Manoj, it will still be maintained. That I'll come back, Manoj. That's a question, Manoj. I'm not yet.
And secondly, is it a case that amongst the reserved category, everybody is EWS and no one is economically better off, so that EWS is presumed in the being a reserved category?
They are socially and economically backward, that is presumed. Within the forward class, they call it forward class, but within the forward class.
So economically weak is only in the forward caste. It's not there in the reserved category. Reserved category, everybody is economically weak.
Everybody is.
Where is that presumption?
I'll place that. There is a judgment. I think that this, with regard to medical also, Manoj.
No, I have noticed that judgment.
I'm sorry, Manoj. This is the first time I have never examined this.
No, everything would have been easy had it been made a horizontal.
That's what. It should have been horizontal.
Everything would have
When
been.
Manoj, somebody told me that this is a vertical thing, Manoj, I was confused. Because that would be
No, even
10% again.
Even I got it, the vertical.
But then I was told, Manoj, that with that judgment, that it's vertical. Thereafter, I did not get an opportunity to examine that. Today, I will.
What is the view of the government to make it vertical, or
No, vertical.
government wants to make it vertical?
Vertical. I'll come back. I'll also examine.
Item 2. All the education measures that should also to consider my events and passing on. Possible final markings for the details governed by the notification. Office memorandum of 2018. Is at page 67.
It's for motion basically. Today.
What had happened here, Manoj? There was an advertisement. Selection was made. I was recommended as serial number 1. He had a grievance. He came up before this one with some marks. Then, my lord, what the government did was requested my BFD, and my lord removed me and appointed. I come
See, merit number one,
up, one, remove.
challenge B.Ed degree question.
There, the general question was made,
Uh,
specifically not made anything. But the government might not decided that I don't have a
B.Ed
in the normal course.
So your
So I cannot be.
Ah.
So my friend's client was given that. I challenged that before your lordship.
in the second rate petition.
In the second petition, the 3558/2020, my lord had an occasion to deal with it. My lord said that you can't do it in this manner. Pronita Sama judgment is there. NCT has to be consulted. So go back and redo the exercise. They go back, redo the exercise because the hearing was also to be done. They redo the exercise, find my degree, their degree to be proper. And I was appointed.
Pranita Sharma means that one.
That 6 months.
At what point of time you made that application?
Okay.
That issue. Okay.
Then, my lord, I was appointed. That was put to challenge on the ground that the hearing was not proper. Because the decision was taken earlier, hearing was done earlier, then the other matters came subsequently. This honorable court might not interfere with the matter
Again said.
and required the government to act upon my lord's order again. The first order, second order, my lord, which my lord has said you hearing should be done. They now hear the matter and my lord reiterate that my degree is proper.
Then
And
this
so
is under challenge.
that is under challenge.
So, this time also, they have considered only the BA degree, so far my students concerned given a reward in marks, then also they have not considered. That was
So B.Ed degree dispute is over.
Over.
But beyond the B.Ed degree, the allotment for marks is not proper. This is your case.
But the order by which my lord had amended back, it was per se or BA only.
Very well. So now he can always make it.
But if he has that grievance, he'll come, my lord will consider the
So,
records.
if it is res judicata, then he can. But I don't think there is any
My lord,
res judicata.
Technically, I can make that paper, but my lord, that point will always be open. It can be kept open. The other point,
Constructive res judicata.
constructive res judicata would come in, because that was not there. But still, my lord can consider that. But my only prayer is, my lord, that there should not be a stay, because there is a finding in my favor from day one. If that has to be reversed, that will be reversed.
No.
On
There-
records.
He's now not challenging on the B.Ed part.
No, not the way.
I never challenged.
Ah.
I never challenged.
Now his challenge is on the question of marks. Initially also it was challenged, but either the court or the proceeding got deviated to some other issue on the issue of B.Ed degree. Now that diverted issue is settled. So we are back to the original question of marks.
So, my lord will also, that constructive res judicata be apart. My lord, I was selected. B.Ed marks I was kept out. Then now, my lord, I have been again appointed. So I am holding the thing. His appointment, my lord, to that extent has gone. Because I was serial number. The day my lord says that my appointment is bad, after consulting the records, I'm gone, my lord. The whole thing goes.
Let us do one thing, Mr. Saikia. Let us call for the records of this election. From the records, you point out where there is a miscalculation of marks. If we find there is miscalculation, we'll send it back to redo it. If there is no miscalculation,
But that can be considered from here itself, because the RTI marks they have given, I mentioned. The 2 marks are under the leadership measure. If the result of the preceding year between 60% to 80%, in that case, these are granted 2 marks.
a result means
School result of the school in the previous preceding year. This is-
okay, the
yes,
result of the school where you are teaching.
yes,
If it is pass percentage is between 60 and 80,
60 and 80.
then you get two marks for that.
Now here it is being given 4 marks.
Oh,
And actually, page,
page number.
page 69. So 2018, this percentage of the school is 76.28.
Page number 69. This is Mr. Nair's client school.
2018 was 76.58.
The relevant years will be past 18 will be the relevant year.
2019 May
Selection took place. So out of 97, 74 had passed.
percentage is
76.
He's attended 2 months.
Ah.
He has been given 4 months.
Hmm.
These marks will be given by page 28.
Page 28.
Calculation at 67.
Page 28, serial number 1, that is number 6 is
Sozol is respondent
that's one number 6. Around 15 that is leadership.
and petitioner is Majid.
Serial number.
Column number
Column number 15.
15.
Leadership and skill. He has been given 4 months.
And no, who is given petitioner?
That's one number 6.
Who is Majid?
Nothing is new.
So you are given 4. No, column number 15 you are given 4.
For me, the kind of question, but I'm questioning he is not. He is attended to 2 months, but he has been given 4 months.
How much you are in that?
I'm 4. I'm in a different school.
Not from a different school.
I'm not in this school.
On what basis is the 4 calculated in the petitioner school?
But that was
Anyway, you are questioning 4.
4.
And where is the principles of evaluating?
Page 67.
68 is the out of the mark 67. The column on leadership skill 4 months total.
Just 67.
7.
Leadership skill total 4 marks. Result of AJ examination in case of graduate teacher and higher secondary final examination in case of postgraduate. This is a higher secondary school.
Has it?
So,
The result of this is
okay, understood. Between 60 and 79% pass marks is 2 marks.
2 months.
80 to 89, 3. 90 and above is 4. So he should be given 2. Yes, what is?
Given one of to become equal.
And that's why I said, how they have given that. So this went up to the state selection. How they have evaluated, let that records be produced for the one. That will be, that will clarify the issue.
The petitioner accedes the selection of the respondent number 6, Sozol Kumar Das. As regards the total marks 4 given under column 15 for leadership skill, by referring to the criteria of giving marks, that is, if in the previous final examination of the school concerned, the percentage of pass is between 60 and 79%, the marks to be awarded would be 2. In the respondent of a school, by referring to Annexure 11, page 69, it is pointed out that the number of students who had appeared is 97, number of students who had passed is 74, and therefore the pass percentage of students is 76.28%, meaning thereby it is between 60 to 79%, and therefore the respondent number 6 would be entitled to 2 marks for leadership quality. The respondents to produce the records of the selection committee, by which may indicate as to why 4 marks was given to the respondent number 6.
But from that, the award of the marks in other ratings also.
In which setting?
This administrative ability. Here he is not entitled to any marks.
Anyway, the records are coming. You argue on the next. This additional argument based on the records you raise on the same. The further arguments of the petitioner regarding the marks allotment for administrative ability and
experience.
experience. To would also be examined based on the records of the selection committee as ordered. List on when you want. Yes, Mr. Sharma, when can you produce the reports? Take a date, list also. Interim order passed on the any day.
I think 3 for admission.
3 and 4 together. In item number 3. Mr. MH law score, then he wants an adjournment. It's the MH law score, then council correspondent 5 prays for how much time? 4 weeks. 4 prays. Little shorter. Oh, it did. Prays for 4 weeks time to find the affidavit in opposition on behalf of respondent number 5. Pray aloud list of
27 September. Item 7.
Anybody appear? Who's for the petitioner? Mr. R.P. Sharma, are we appealing for item 7?
On the date of the celebration of
Mr. Sharma, on the last occasions, none appeared for R3, 4 or 5. You appeared. So it was adjourned for that reason. Prior to that, none appears for Assam University adjourned. Who appears for Assam University? Yes, you can very easy. Also, who you sent here? Because they just call that person. Not to come. You hit the audio, you hit the audio. Spread around everyone here. Where is Mr. Kia? Mr. Odhikari is with you, Mr.
Yes.
Can you hear it today?
No, he is not there, but he has come to
Who? Mr. Kia?
tomorrow morning.
Mr. Kia?
Yeah.
Oh, Odhikari, it's okay. Today you are there. So what do we do? Mr. R.P. Sharma, Land Senate Constable Petitioner, as well as Mr. T.A. Chaudhary, Land Council Respondent 3, 4, and 5, and Mr. A. Ahmed 4. Who is Respondent number 6? What university is present? So is Mr. A. Pravila for the Higher Education Department, and Mr. P. Saikia for. He's coming. Timing or some other day? You take it. Tomorrow will be difficult. Or take up after some. Let me start here. Or as you prefer. Day after tomorrow. About the matters are there. That's why we take it up today only. Yes, Mr. Kiel, are you ready? Are you ready? Mr. Sharma is expressing some urgency. But Mr. S.C. Kyal and Council for Assam University indicates that as the cost is did not indicate a name, so therefore the land council is inconvenienced. Sorry. Assam University. No, just see this order. I don't know. It's wrongly typed or even just check out? No, sir. Then we can hear you because everybody is here. You are there for Guwahati University. You are there. Are you ready? Are you ready for the Guwahati University? Sorry. So you don't have to make any submission. Then are you? Who are your clients? The college authority. So you have expelled them.
Yes.
Why?
It's against the principle of the college. There is some strict guidelines.
Strict guideline of the college. What? Which guideline was violated?
I have submitted maybe in my short version. The prospectus is a violated version. I have filed my affidavit.
You have to publish any guidelines to us.
There were suppose notices, they replied, suppose the college was convinced on the reply, and accordingly they were expelled.
Impugn order dated 1/7/2022. Azimuddin Tajuddin, expulsion order. This Haji Alfad is a what kind of a college?
Government college.
Government college.
Government.
For doing immoral activities in the campus, which has gone viral in the social media for violating college discipline. Also to inform you that as per decision of the staff, you have been expelled. They are students.
Yes, sir. You will not say, well, what is the immoral activity? You are dancing.
And 6/6, which are considered informed that your client has been received by this college. Now that you have comparative remarks, whether you have alleged that the video which has gone viral is edited by somebody. Now, where is your show cause? Page 7. No, I have read that. What is the statement of allegation? No, no. How does the show cause read? Where is the allegation? What they have done? What are the charges? Indiscipline is an act. Indiscipline cannot be a charge. A particular act that may have been done may be constituted to be indiscipline. But what is that act? What they have done? Dancing. So, where is your allegation that you are dancing? We understand everything, but these students have to know what is the allegation against them, what they have done. Otherwise, how they can give a reply? So we have read it. This is precisely we are asking you. Suppose today Mr. Sharma says your behavior is very indecent in the court. Next question you are going to ask Mr. Sharma, what did I do? That you are telling me I am indecent. Sharma may say your shirt is this or your manner of standing is bad. Then that will be the act you can give a reply. But if he only says your behavior is indecent, what reply will you give? Next reply will you give? No, my behavior is very decent. End of the matter. So, how can you extract a reply, extract the act to be done from a reply? It should always be from the show cause notice. Then I think it will have to go. Take back the students. Understand? No, that you face the responsibility for being not for dealing with a student in a prejudicial manner. You take the responsibility. Whatever is the outcome, you face it. Mr. Chaudhary, two things we have understood from your argument. One, the alleged act that they have done flows from their reply, not from your show cause. Based on that, you have taken action. In the meantime, the semester is over. So we cannot do anything. Are both the replies acceptable in law? So this is a presumption. Precisely, I am saying. Suppose Mr. Sharma raises this allegation against you. What you are doing is indecent, unethical, immoral, and all. It doesn't say anything what you have done. Can Mr. Sharma take a view that everybody in this courtroom knows what you have done? Is it admissible in evidence unless proved? Or can any presumption be drawn? So tomorrow, if somebody puts up something under social media against a person, is it conclusive that that person has done that? Who? No. The person against whom allegation is that he is not required. It is you who are required to have the material with you before you make the allegation.
They have claimed that this video was proper. People edited. That's why asked for the original.
You think over what you are submitting, whether it is acceptable in law or not. We cannot be if you are done an illegal act, we cannot allow you to be that. So you take the responsibility, compensate it in whatever manner you want to.
The other two times of notice, so they have replied.
Mr. Chaudhary, multiple show cause notices will not improve the situation. In fact, the subsequent show cause notices are not tenable at all. There can be only one show cause notice on one allegation.
Yes, sir. So regarding this incident, also inquiry committee was constituted, also inquiry committee examined the matter, thereafter they were investigated.
Here's what you say. Are colleges permitted to investigate in this manner? Do you support the? I don't think anybody will support you. I understand. So we allow this petition with a cost being imposed on harming the career of the students. And number one, what did they do? If I have understood correctly, by all the subsequent materials, after the farewell of a teacher, they were dancing. Is dancing an immoral act? Just a minute. Is dancing an immoral act? Is dancing an indecent act? Is dancing an unethical act? For a college student, after a regular farewell function, if one or two students feel that, yes, your principal could have come and prevented that. Please don't do it.
Serious because they were spoken start and video were published in the social media. Then the public demand also came in press. College authority come under pressure also.
So college is acting on pressure of the public, not under the law.
No, under the law also because the college is in the discipline.
Think about it. Think about it. If you decide, it may go a little against you. If you want to withdraw all this, take back, you take back. You are free to go. Yes, Mr. Tobita, what do you say? Does the director approve this kind of behavior of a college? Sorry. How many times it is adjourned this matter? And what does the Guwahati University say? Somebody will understand. Do you approve this kind of a behavior of a college? Do you approve? Being the university, being affiliated to you, do you approve this act of the college? No one approves. The Chaudhary, confined to the legally acceptable submissions. Tell us whether you want to withdraw this order or take back the students. Or else if you decide, it may go a little against you. You may order action against the college authorities also for spoiling careers of students, which could have been tackled in a much different manner. If the students are dancing, you don't want them to dance. Prohibit them. Ask them not to dance.
It amounts to moral goods.
What that's a extreme punishment. And students there at a tender age, they may go a little here and there. And the college authorities having the role of a guardian is also required to guide them, not be harsh on them. What is this college? Haji Afsar Ali College, Dohoka. If you spoil careers of this one, we may ask the education department to cancel your registration of the college. Do some other act. If you are interested in moral policing, you adopt that profession. You stop being a college. Or what else to do? No, every college is known for strict discipline, and there is no college which is indisciplined. But there has to be a proportionality between the act done and the action taken. Some balancing also has to be there. Suppose this is a very strict college and the act done by the student would have been a little more severe than this one. What would they have done? You had to hang the student. Same, go by same proportion. Sorry.
After tomorrow, Friday, madam, why is the line? He said it's fine.
By a show cause notice dated 1/6/2022, addressed to the three red petitioners, the principal of the respondent, Haji Anfar Ali College, had asked them to, had informed that they have been suspended from the college for doing indecent, unethical, and immoral activities in the campus on 31/5/2022, which had gone viral in the social media and therefore violated the college discipline and rules. Accordingly, the petitioners were debarred from entering the college campus, which if violated would have invited legal action. The students, by their communication dated 4/6/2020, one of the students, or all of them. One of the students, Tajuddin, by his communication dated 4/6/2022, addressed to the principal, stated that after the conclusion of the farewell ceremony of one of the teachers, a dancing clip of himself and two other students, Mukhtar and Azimuddin, were circulated in the social media Instagram, which again was edited by someone and then uploaded in the social media. The student, by expressing remorse, had stated that he had realized that the act of dancing ought not to have done, and therefore requested for being pardoned. The college authorities, by another show cause dated 6/6/2022, informed the students that some contradictory remarks were found. That the video which had gone viral was edited by someone else. The college authorities questioned that on one hand, the student had accepted the video had been recorded on that day, and on the other hand, it had been alleged that it was edited stroke doctored. And therefore, the student was directed to submit the original one, failing which formal procedure would be adopted as per rules. The students again tendered an apology by their communication of 11/6/2022. By the communication of 1/7/2022 of the principal, the three students were earlier suspended from the college on 1/6/2022 for doing immoral activities in the campus, which had gone viral, and for violating college discipline and the rules. and as per the decision of the staff meeting held on 25/6/2022, had been expelled from the college for involving in a number of indisciplinary activities in and outside the college. And accordingly, a compulsory transfer certificate was issued in their name. It is noticed that the order of expelling the students was on the basis of some immoral activities being done on the campus on 31/5/2023, which again had gone viral. And it was done as per the decision of the staff meeting held on 25/6/2022, wherein a conclusion was arrived that the students were involved in a number of indisciplinary activities in and outside the college. So it has to be understood that the students were expelled because of many indisciplinary activities, which the staff meeting took note in its meeting. Staff meeting took note on 25/6/2022. In other words, it has to be understood that the expel was done by reasons beyond the original reasons provided in the show cause notices dated 1/6/2022 and 6/6/2022, which were confined to certain indecent, unethical, and immoral activity on 31/5/2022. The respondents to show cause as to in what manner the procedure adopted in expelling the student would be acceptable in law. Based on, for 13 part, based on 21/9. 7 for the yes, Mr. Sharma, 7th will be little difficult for that. 7th will be little difficult. Number of matters are there. The respondents to also college authority to also explain as to what is meant by an immoral act, indecent act, and unethical act, which had been attributed to the students. Further, the respondents to also explain as to, on the basis of the aforementioned Choco's notices, how does students are to understand as to what is the alleged act against them.
Are there any orders?
Yes, Mr. Hazarika. Not to give reply. Mr. S. Hazarika, land counsel for a petition of praise for how much time? 2 weeks time to find a reply to the affidavit.
9 and 10 for hearing.
Harder? Must be because I'm not holding.
Yesterday, she could file the affidavit. But I received a copy yesterday. It was the presidential order of my lord.
No, today what is to be done? Can you hear the matter?
She has filed yesterday on record.
It has not come in reply.
Today, I would also like to
Reply. It is stated by Mr. H. Buragohain, the counsel for the petitioner, that an affidavit had been filed by the respondent in course of the day to which the petitioner would like to give a reply. And further, the affidavit is also not on record. List along with the affidavit as well as the reply of the petitioner to be listed on.
I think 11.
Thank you. I think we'll have to hear this one. We'll decide on merit. Because we tried something, it did not take place. We'll decide on merit. Merit of the appeal. How long will it take? It's likely to take longer going by the. No, we'll take up today only. No, some motion matters are there. Even not today. Okay. So when do you want? Seventh is too full, what I have picked to. It's agreed by Mr. D.K. Mishra, Senior Counsel for the applicant, as well as Mr. R. Dubey for the respondent, that the hearing the matter be deferred for the day and be listed again on 21st. We want it little earlier to that. No? On 21/9/2023, list on 20.
12 to 15.
What are these 2011 matters? When we are
This was regarding challenge the transfer order to petition. The petitioner has in the meantime
Mr. Tiwari, you appear in item 14.
Yes, my lord. But
Who appears in item 12? SSD D.K. Mishra.
item 12 is a checkered history.
No, Mr. Mishra is not appearing
That's
anymore.
why I'm saying it is a checkered history. Initially, Mr. Mishra appeared. Then after he withdrew himself, then there was an entry of Mr. SSD. After some time, Mr. SSD also withdrew himself. Then for some time, Mr. Kamal Agrawal was clear of the case. Then after he also withdrew himself. And then we got receipts that the case was amended. In the pre-COVID time, the cases came up before my lord this occasion. So I argued in one of the connected matters for quite some time. But then wisdom, ultimately the honorable court realized no fruitful purpose will be served as the matter was somehow deferred. And now it has come. So far as 580 is concerned, I do not know, I'm not sure if anybody really will appear. And if 580 nobody appears, then
The rest also falls true.
other case, especially in Lord WPC 2386, which is item number 14.
Where you appear.
This writ petition is a counter blast of 580. If the 580 is not pressed, then I'm also not interested in this.
Understand.
Purpose will not be served. Because practically some of the basic things that we wanted, we have already got. Because in 580, the principal relief they were seeking is deprovincialization of the allegation Hindi high school. Deprovincialization in 580.
So who is the petitioner? Managing committee.
The petitioner at that point of time when it was filed, Mr. Ramesh Chair, who happens to be one of our esteemed colleagues, he was not president of the managing committee in that capacity. He had filed the
Mr. Tiwari, possibly the issue is, I don't know, appears so, seeing the name and the area of the parties. They possibly claim to be a Article 30 institute.
article.
Most likely.
Yes.
Once it is an Article 30 institute, it should not be provincialized.
This is
So therefore, the managing committee is against the school being provincialized.
yes.
Most appears
That
so
was
from
the
the.
case. That was the case they projected. As a counter blast on behalf of the guardians and the Hindi-speaking community, we got ourselves implicated as respondent in WPC 580. And our counter case was that so far as the petitioner is concerned, they are unelected body. They do not even represent the minority. So they do not have a locus to seek enforcement of their fundamental right under Article 30 of the Constitution. And then as a counter blast, we filed.
And what about the others, teachers and students?
Teachers also they were against it.
No, they want provincialization or they
Obviously,
don't? Everybody wants.
No, not only guardians, teachers, everyone else wanted the school to remain provincialized, but after that first Supreme Court judgment, Supreme Court did not say the school should not continue in the provincialization.
That The TMFI.
Yes, there was.
Not
Actually,
TMFI.
what happened was,
Oh no, I think for this school only there is a Supreme Court somewhere. Either this school or another Hindi school of the.
LOG in the high school belonged in Ambika Prasad Kedia. This question had gone to the Supreme Court in Ambika Prasad Kedia. And in connected matter, LOG also had gone to the Supreme Court. So there, they had assailed the virus of Section 5 of the 1977 Provincialization Act of Assam and also the Rule 4 of the 1976 rules. So Section 5 as well as Rule 4 were struck down by the Supreme Court being ultra virus of Article 30. But at the same time, the Supreme Court did not make any whisper so far as continuity of the provincialization is concerned. Then subsequently, my lord, the same judgment of the Supreme Court was noticed by the two subsequent division benches of this honorable court. And in both the division benches, the second division bench, LOG was a party, one of the parties. So the division bench tried to reconcile the provincializations with the autonomy of the managing committee. So be that as it may, not all these things are in the merits. So the substance of the whole thing is WPC 580, they wanted deprovincialization. At that time, Mr. Ramesh Jain was the president of the managing committee. Our case was managing committee is not an elected body. Representative of guardians are not there. No election was there. Nothing was there. They do not represent the minority at all.
So you're telling the basically the locus of this.
Yes. Apart from that, we also filed our affidavit in opposition, and then as a counter blast, we filed WPC 2386, item number 14.
With what kind of prayer?
There were three prayers. The prayer number one was, in order to reduce the number of students in the school, then it changes the different. Because the prime land might not move the location of LOG, just opposite the Bharti Park. So, what they did was to reduce the number of students, they stopped admitting the students. So the first prayer was the students may not be admitted in the school.
By the guardian, basically by the guardians.
Yes.
And who stopped the school authority?
Yes.
They wanted to reduce the number of students because the locality is very crowded.
The reason they gave all the amenities are not there, laboratories are not valuable, all kinds of excuses. Be that as it may be, not
Against the same managing committee.
Yes, yes. So as of today, the girls are there till the class 10 admissions are going on. So that part was over. The second was, we sought a counter relief by way of the school's direction in a different way. The school should not be deprovincialized. We spoke about the efforts that are being made against for deprovincialization, and we wanted a relief against that.
That is some other writ petition.
In item number 40.
Here only you got that
Yes,
order.
yes, here.
It's an interim order.
Yes, and then the third prayer we wanted the full interim order as such.
It's a
And
final
the
order.
third prayer we made in item number 40 was that managing committee should be in elected body because elections were not being held. So, in the meantime, what happened was during the intervening period, one managing committee after another managing committee, as of today, there is no managing committee. So everyone is happy. There is no managing committee, and it seems that the government of Assam is practically controlling the school to the headmaster. So all are delighted. And
let's do one thing, Mr. Tiwari. Today, let us pass an order. None appears for the petitioner based on so and so. In the event of further non-appearance, appropriate order shall follow. On the next day, dismiss for default. If somebody is interested, they'll come back for restoration. If somebody is not interested, that will be the end of the matter.
May I put it this way? What I was thinking was that if WPC 580 is not pressed, that is item number 12.
No. Somebody will have to come forward and say we are not pressing. And as you say, your last sentence caught my attention. That this is the succeeding managing committees which took over. Now there is no managing committee. So even if we now issue notice by the registry that none appears, we issue notice. Notice to whom will the notice go? To the original managing committee, non-existent. To the present managing committee, again non-existent. Intervening managing committee, which might have been existing at some point of time. So instead of going into these complications, if we dismiss for default, okay, and require the registry to serve a copy of the dismissal order to the school authorities. If they want, they'll come forward, and whosoever comes forward will understand that there some authorized authority. Carry forward.
In fact, Lord, I passed on the information to those who had engaged us. And of course, everything.
And
was explained to them.
your item number 14, it will be a consequential closure. Again with liberty, if somebody comes with for restoration of 12,
This is what I.
this will also will be revived on its own.
This was what passed in my mind, and I wanted to communicate.
So let us pass that order. Otherwise, what else to do? It's an
That's better.
situation of impossibility before the court. No? And what is 13 again?
Other cases, Lord, I know.
No, it's again in between number 13 is there.
This was a challenge to transfer of the petitioner who was an assistant teacher in the Bharat school.
It is no way connected.
It is
No way connected with the other
No,
dispute.
it is not connected.
Plus, it has become infructuous.
So, just because it has not been written. This can be closed.
We closed it on the next day because it is 3 writ petitions, WPC 580/2013. What is again review petition? Review petition 136, this corresponding to review petition 136/2012 disposed of, comma, WBC 2796/2011 and WBC 2386/2013 are listed analogously. Mr. P.K. Tiwari, learned senior counsel for the petitioners in WPC 2386/2013, had stated that WPC 580/2013 was instituted by the Managing Committee of LOG Hindi High School.
Did they manage it?
Deliberately indicating it. By the Managing Committee of the LOG High School, assailing an order passed by the authorities in the education department by which the school was provincialized. Or what?
This was the prayer Milord was to the effect that the judgment of the Supreme Court in the Amrita Prasad Kedia should be strictly implemented. It was in that.
Impliedly seeking, impliedly assailing the provincialization. Mr. P.K. Tiwari, the Senior Counsel, has made a statement that WPC 2386/2013 that the petitioners of WPC 2386/2013, or some of the petitioners, were also respondents in WPC 580/2013.
They got themselves completed.
They were got implemented as respondents in WPC. Further, WPC 2386/2013 had been instituted to counter the reliefs sought for in WPC 580/2013 regarding impliedly assailing the provincialization of the school. It is stated, Mr. Tiwari Senior Counsel also states that the locus standi of the Managing Committee who had instituted WPC 580/2013 is also being questioned, inasmuch as there was no such existing managing committee at that point of time which would be acceptable in law. It is also stated that over the years, the state managing committee had given way to some succeeding managing committees. And the ultimate situation is that presently there is no managing committee of the school. Some of the issues raised in the 2 writ petitions are also continuing in the same state as it existed when the writ petitions were filed. None appears for the writ petitioner in WPC 580/2013. Although it is stated that several learned senior counsels were engaged from time to time, who had also withdrawn from the case in course of time, and presently None represents the petitioners in WPC 580/2013. Consequently, we have to understand that when the matter is called up for hearing today, none had appeared for the writ petitioner in WPC 580/2013. List again on 2 weeks one gathered us. On so and so for so and so. In the event none appears for the writ petitioners for a petition in WPC 580/2013, appropriate order shall follow. The registry is directed to provide a copy of this, transmit a copy of this order to the authorities of the LOG High School, which is stated to be located at Fancy Bazaar, Guwahati. Okay. How will you transmit? Through email?
I can call some of 5 people.
Or a full stop. The order may be transmitted and made available to the Learned Counsel assisting Mr. Tiwari in WPC so and so to be delivered in the office of the LOG High School. If they come, they will come. If they don't come, it doesn't. Your case also, we take a note of the statement of Mr. Vishwakarma. As Vishwakarma, Learned Counsel for the petition at WPC 2796/2011, that this writ petition ordinarily ought not to have been listed analogously with the other 2 writ petitions, inasmuch as the subject matter is different. That a teacher of the school had assailed an order of transfer, which again has become infractious in the meantime as the concerned teacher has retired from service. Appropriate order in the WPC shall also be passed on the next return date. GP Bhumik, does he come to the court regularly? Does he come to the court regularly, GP Bhumik? I know, I know. What to do? R. Hazarika. See if he wants to come. See if Mr. R. Hazarika is available. So it should go to Bench Street. So wait, listed here. What to do? That's it, okay. None appears for the petition. Otherwise, this bench aspect, suppose even if it is a bench tree and listed here, are we supposed to send it to bench tree or we can take it out? Why? So where is that provision? The list is published under the authority of the Chief Justice. He is the master of roster. If Chief Justice, by virtue of the list, deems it appropriate, it is listed there. Anyway, for today, I don't use. And if it is bench tree, it will inform Kori 24 to be listed before bench tree.
I think 17 for motion.
Yes, request of Mr. Washing. Notice yet to be issued. No, no. Notice is yet to be issued. Yes, who appears for the respondents? So, Kaushik, you appear? Notice is yet to be issued. So let us hear the petitioner for motion. Yes,
The petitioner second the Indian order dated 10/7/2003, 2023, issued by the Director, District Elementary Education Officer, Morigaon, whereby the presidency of the petitioner.
No, no, which page is that order?
Ordering page 35.
This is the what is your case?
Petitioner of the president, elected president of Lordship SLC of Rosanaburi and his group. A new version was published in Lordship electronic media regarding misappropriation of MDM rights. That Lordship inquiry was conducted by the PEO, Local Education Officer, and he submitted his report. The report is Lordship at page 27. And in this report, Lordship, there was not a single allegation against the president of the SLC. All the allegations were against the
This petition is by the president, not by the secretary.
not by the member. Is the member secretary is the headmaster teacher, and I am the elected president also.
Where is the inquiry report?
Inquiry report is the page 27.
Yes, why do you say president is not involved? So why? And there's no report against the petitioner.
Lordship, in the inquiry, Lordship, the DEO, Lordship, requested the DEO, District Elementary Education Officer, to take immediate action against the.
No, that is okay. Inquiry report.
Yes.
Why do you say there is no report against the president?
Lordship, in this inquiry, Lordship, the president was not called for. His statement was not recorded. And moreover, Lordship, the headmaster, Lordship, he has submitted his statement. Written statement before the inquiry. And this is in page number 29 and it's not 3. And particularly it is page number 30. Take statement before the media last to get released from the IC headmaster.
Yes, Mr. Koshik, page 27. By this inquiry report, what is proved?
This inquiry has been done, my lord.
Understand? No, what is
Only
proved?
the records has been seen.
No, no.
Not that the statements of any of the parties.
No, it's not on that. Please, madam. What has been proved? See, allegation is, as per electronic media, headmaster and president has sold. Allegation is sold. Okay. Now you read further, paragraph 4. Where is the finding regarding rice being sold? Where is the discrepancy? There is no discrepancy. I've read the calculation.
It's in popular 69 out of 58
To be stock.
to this stock.
Ah.
And the physical stock.
Why do you say it should be 69? Because total rice received is 228, less expenditure with extract from 15 to 12.6. That is, expenditure means less expenditure is
159.
what does it mean? Less expenditure consumed, given to the students.
Period is 150.
Stock to be at the godown is so. So what happened to this 25? How many kgs? 25,000 kg. What happened to this 25,000 kg rice?
Lordship, regarding these discrepancies, the president is nowhere related to this.
See, rice is given to the school managing committee, which comprises of the president as well as the secretary. Rice had been received is 200 and some 28,000 kg. Out of that, 159 kg had been consumed, given to the students. Balance ought to have been 69,000 kg. So 1,000 or whatever it is. 1,000 or what is the figure? Very difficult to read. But the school is having only 44,000 kg. So that means 25,000 kg is not there. If the rice is given to the president and secretary and the rice is not there in the school stock, what happened to it?
Lordship, the maintenance of this lordship go down. It is the headmaster lordship, member secretary.
Not the president. What are the responsibilities and duties of a president? Is the president not equally responsible?
President, responsibility of the president is only
Okay, we are issuing notice. There cannot be any interim order. We have to hear that. Sorry.
This arrangement has been made only for a temporary purpose.
Lordship, moreover, Lordship,
But
there-
temporary goes on and on.
and Lordship, there was no provision for withdrawal of presidency, Lordship, as per this.
But if a man is indulging in rice disappearing from the
That is
school,
not reflected in the employee report, Lordship.
it is reflected. And there is no explanation. And moreover, you see, come to page 29, what the headmaster says. I applied for not to take charge of headmaster because of my physical and mental illness. But on so-and-so authority had given me the in-charge headmaster. At the time of taking charge, I noticed that there was no MDM rice in the godown. It had already disappeared. Due to necessary interference by Ikramul Haq, he is the petitioner. Ikramul Haq, I failed to manage the school. I was physically and mentally ill.
Lordship, unnecessary, Lordship, being a president of the SMC, Lordship, it is the duty of the president to ask for a monthly account of the Lordship, expenditure of the school, Lordship. And
The president does not have any responsibility and duty or what, other than asking. This is the composition. What is the duty of a president? It often does. Ati action sab.
Accounts of the schools and everything is jointly handled by the principal, the headmaster, the member secretary, and the president.
কিরকম আরটি এগুলি রাইট টু এডুকেশন তলখন ভালো যে School managing committee, which section, Mr. Kaushik?
Lordship, it is in page number 5, powers and functions of the SMC.
Page number 5 of what?
This is, I have given a notification. Lordship.
Say, Mr. Kaushik, if you go to Rule 13.5.3 of the Right to Free Education, that Rule 2011, the removal of the President, Vice President, member of the SMC shall come into effect from the date of approval of the resolution of the SMC. Where is the resolution of the SMC? DO cannot do it on his own. May not be. Removal of President also, I guess. That requires the approval of resolution of SMC by the district elementary education officer. So he is only an approving authority. He is not the authority to remove or withdraw. Minus the SMC resolution. Sorry. Understand. Understand. So there ought to have been a SMC resolution recommending his removal. And in that resolution, this person would have been given the opportunity to explain their case.
Perhaps follow the manner how why the DO has said to convey the meeting immediately.
He cannot take the action first and then regularize it.
Because
First he had to.
we were the last person.
That will not help you.
The headmaster in charge of the school shall take necessary steps for conveying a SMC to hand over in charge of the presidency as per recommendation of DO.
Ah,
The vice president.
so how can you direct that?
Very temporarily.
No, nothing temporary. Temporary removal is also a removal. The law does not say distinguish between temporary removal and permanent removal.
But it is a situation where the president and the headmaster have been found to be involved with.
This is the difficulty.
In such a scenario, the meeting would not be held.
Why it not be held?
Because the president and all the
It will be conveyed to the vice president. And in that meeting, these two offending officials will be explained of what has been found against them. You will hear what they have to say. Then the committee will take a resolution, whether to retain them or to remove them. If the resolution is taken to remove them, it will go to the DO. DO will approve it. On the approval, the removal takes effect.
but if the vice president will convey the meeting only in absence of the president. If the president is absent or president has been
Sorry,
has resigned.
sorry, we have to go by rules. We give you liberty to follow the rules if you want, but the timing we have to stay. That is, removal has not come into effect. We can provide in the interim, this removal has not come into effect because the procedure was not followed. And we give you liberty to follow the procedure if you want. The charges are serious.
Charges are-
I never say that this man should continue.
And if you also find the president.
But difficulty is what you know. As you have not followed the procedure, now madam is making all kind of counter allegations, which we are required to decide. But this would have been decided in the resolution of the SMC, this factual aspect.
If the serial number 7 and 8 of the notification is it shows all of that the president and the member secretary has been given a joint responsibility in every aspect. And
That-
now it is the allegation against the
Understand, Mr. Kaushik, we accept that. That's why we asked her.
if not you observe that.
The first submission was it is only against secretary, not against president. We rejected that because they are both jointly responsible.
One has
But you have to follow the procedure. What do you do?
given the liberty.
Interim stay. Your name? R. Gogoi. Third MSR Gogoi, third counsel for the petitioner, also head Mr. P. Kaushik, counsel for the education department. The petitioner is the president of the school managing committee of what school? Of Losonabari MV School. Certain news appeared in the electronic media that the in charge headmaster of the school, Muhammad Nur Uddin, and the president of the school managing committee, who is the writ petitioner, had sold 20 quintals of midday meal rice of the value of rupees 70,000 and divided the amount amongst themselves. On the basis of such allegation in the electronic media, an inquiry was conducted by the Block Elementary Education Officer and submitted an inquiry report dated 26/2023. The inquiry report reveals that there is a shortage of rice in the godown of the school amounting to 25,58 full stop 960 kg. What does it mean? It is 2,500 kg. In view of the difference in the availability of rice in the stock of the school, the district elementary education officer requested the district elementary block elementary education requested the district elementary education officer Morigaon to initiate immediate departmental action against the in charge headmaster of the school, namely Nuruddin. The inquiry report did not recommend any action against the president, namely the writ petitioner president. Then where is the order removing you? This is the only order. 35. In the resultant situation, the order dated, the order impugned dated, what is the date? 10/7/2023 was issued by the district elementary education officer, by which, based upon the inquiry report of the BEO dated 26/2023, the petitioner as well as the in charge headmaster Muhammad Nuruddin were withdrawn from their respective posts of president and secretary until further orders. The order dated so and so, withdrawing the presidentship and secretaryship of the school management committee, is a sealed in this petition. Rule 13 5 small Roman 3 of the Assam The Right of Children to Free and Compulsory Education Rules 2011 provides for the procedure for removal of the president and member secretary and members of the school managing committee. Rule 13.5.3 inter alia provides that the removal of the president or the members shall come into effect from the date of the approval of the resolution of the SMC by the district elementary education officer concerned. A reading of Rule 13.5.3 makes it implicit that there is an inherent requirement of a resolution being taken by the school managing committee for the removal of the president or the secretary in the event of there being any allegation against them warranting such removal. In the instant case, it is noticed that the required procedure of there being a resolution by the school managing committee is found to be prima facie absent. And it appears that by acting on the report of the block elementary education officer, the district elementary education officer had on her own had withdrawn the president, petitioner from being the president of the school managing committee, which apparently appears to be an aberration of the required procedure of law. In view of the above, in view of such prima facie conclusion, the order dated 10/7/2023 in respect of withdrawing the president of the school managing committee, in withdrawing the presidentship of the school managing committee of the writ petitioner Ikramul Haq is stayed. But however, it is noticed that the allegations against the writ petitioner are serious enough for an appropriate consideration. Accordingly, in spite of the order, liberty remains with the authorities to follow the proper procedure of first taking up the matter through the school managing committee regarding any resolution that may be taken, and thereupon the matter be taken up by the district elementary education officer for its approval as required under the till such further exercise is undertaken, the interim order as indicated above shall be.
Item 18.
18 and 19 is the common issue. Also, background. 1958, Assam Agriculture University Act was enacted, and Assam Agriculture University was established. In that act, there are two sections. Section 40, it says that there are certain faculties, different agriculture faculties, the veterinary faculty of veterinary science. There will be different faculties. Then there is section 26 of the act says that dean of the faculty will be the head under him there will be different departments. And after that time, under the Agriculture University Act, there was statute was formed. So rule 1, chapter 1, rule 1
Of the statute.
of the statute. It was provided specifically for a detailed procedure for appointment of dean. Because the act says he will be a full-time officer. Procedure is very stringent procedure, very good procedure. That there will be first scrutiny of the people, probable people. Next is an advertisement. Next is as another.
Advertisement, only those scrutinous people can participate.
No, it is open to all.
Then,
First is the advertisement, then is the scrutiny. I'm
Oh.
sorry, I said that.
sorry.
Then after that, a selection committee. And who will be the member is also given. Then after that, a list will be made in preference way, 1 to 3. That will be approved by the management. And this is how the dean will be appointed for different faculties. Now, in 2018, the two petitioners before your lordship, by two petitions, they were, while going through the same advertisement process, they were appointed as dean. Now, what has happened in universities, in many universities, the situation changes. As our term is now slowly coming to an end, advertisement is not issued. 18th of this month, they have proposed at page 78 that also in a wrong language. Page 78, your lordship will see, they are proposing an amendment. Page 78. I'm sorry, 87. 87, I said. I'm sorry, I said correctly. Page 87. One of the proposal is in the absence
This is still in the proposal stage.
proposal says. Now, since our term will be over, in how to come out of the stringent procedure, no advertisement, so that there will be no
put in your application.
Mhm.
So I can have my own elected head of the department. A proposal that has been made in the absence of this language also is going wrong. In the absence of the dean on earned leave, etc., will be assistant generous, not on a regular vacancy, like earned leave, medical leave, and all. The senior most head of the head of Now, had it been like, now, statute they cannot.
The head of the department nominated by the vice chancellor shall act as
Now, your lordship will now compare page number 51. It has to be now avoided page number 51 statute.
What is the beginning of this page 87? What document is this actually?
This is a proposal. There are different sections they are trying to annex our act
No,
inside.
that's what I'm trying to see.
Annex our act at page 75 inside.
Well, page 75. First statutes under Assam Agriculture.
That proposed is nil. Everywhere they are nil. Then they are finding a way out.
No, now this 87 is a proposal.
Proposal. Now, in the meantime, they have also. By the way, may I have the indulgence?
Sorry. Yes.
I'm saying,
Yes. Yes.
page number 51 you look.
No. This column on the left hand side is existing.
Left hand side is existing.
And middle column is proposal.
Proposal. In the
One at page 87 is the left hand side. So must be existing.
Let me check out. Your lordship may be right. Your lordship may be right.
Because if you come to page 75, first is serial number, then existing, then proposed.
My lord, your lordship.
And it
I stand
is
up, page number 53. I'm sorry, man, it is already named.
it's already
Yeah,
page
my lord is right.
53.
Because page 53 has a lordship.
So, Mr. Kotoki, is the page 75 the existing first statute?
Yes, your lordship.
Existing, yes.
It is the existing first statute. This existed since when?
The first step was first.
When the university, that after that relevant provision.
Proposal of the act. Publication of the act. That made it wrong. Submission.
Your lordship, I can say it's page 52. Page 52.
The vice chancellor is the next day approval of the chancellor due following first.
Page 52. Page 52, powers and functions and duties of the dean. Page 52, bottom. The present statement. Powers and functions.
Page 52
Bottom.
is
Powers and functions.
of the deed.
Then your lordship will look at rule 4.3.
This is the act. 60 is the act.
Yes, rule statute. Your lordship is have rightly pointed out the mistake. I stand corrected.
No, it's just
In the absence of the dean, on earned leave, etc., a head of the department.
where you are reading page?
Now, page 52, your lordship.
52.
Page 52, rule 4 starts. Rule 4, sub rule 2. Next page. Page 53. In the absence of the dean on earned leave, etc.
Page 52.
Page 52.
Sorry.
Powers and functions.
The dean shall be directly responsible.
And then 4.2. Next page. Next.
In the absence of dean or earned leave, etc., head of the nominated by so same thing.
Same thing. Your lordship, I stand corrected. It is also in the proposal. Your lordship, but this assistant generalist, dean, it cannot give way to page 51. Page 51, your lordship, kindly see. There is an elaborate procedure. Page 51.
Manner of appointment of deans.
Yes, by the lordship. Appointment of deans of Page 51.
Mr. Sharma, this page 51 and 52, it's a part of the same document. Same document.
Same.
statute. It begins with.
Okay, you made a photocopy from Northeastern Local Act, that's fine. No, one page it is coming Local Act, next page it is coming name of data. No, it's okay. Means because of the book it is coming like that.
Page number 51, the
Mhm.
manner of appointment. The appointment of deans of colleges.
Yes.
The qualification required to be for this post will be fixed by ICA. So, there is a specific procedure. Now, post 1 comes under the heading powers and functions. If the dean is absent due to his illness,
Then what will happen?
what will happen? Now the advertisement is due. Our term is also expiring. My feeling is we will invoke, they will invoke in the absence. So head of the department. This is my,
Is there any provision for extension?
there is no problem. There is a peculiar, your lordship will again see 4.2 comes under 4.1. 4.1 is the powers and functions of the deans. What?
4.2 is a provision to exercise the power in the event the dean is on earned leave, what will happen,
On medical leave, etc.
etc. What will happen? You will appoint a head of the department to discharge that duty, and not only appoint, nominate to shall act as the dean. He will only act as a dean. He will not be a dean.
Now, in order to create an ad hoc dean, they have decided not to go by the.
Now today is a
May I just submit like this?
Yeah.
If your lordship ultimately it's your rich request, let that issue, because it is not only me, many other people ICR will depend. And let them complete the process within a period of 2 months. And in the meantime, I am already selected. I am already going. Let the university not suffer. He is the head of the. This interim arrangement, let them continue. Moment they select, this will be.
Let them, I said they will decide. Because you
I should
already,
have decided like this.
because you already get location.
We will take it up tomorrow, produce the decision of the Vice Chancellor. If the decision of the Vice Chancellor is consistent with the provisions, we will not say anything.
Now,
If the decision of the Vice Chancellor is not consistent with the statutory provisions, then maybe we will have to say something.
From the register, one is that actually the age of retirement of dean was 60 years. Recently, the 100 captain meeting, government had against to 65 years. Because of that, actually, advertisement.
So this petitioner dean, he will retire at the age of 60.
60 years. Now, because of the every decision, now this there has been notification from the government. After receipt of the notification, we will immediately go to that.
Why?
Because government has.
No. That is no way related with the issue. Mr. Kotoki, we understand. Why do you have to wait for the final decision, whether it is 60 or 65? Whosoever is appointed dean, as of now, if it is 60, he will retire 60. If it is 65, he will retire 65. But why do you have to wait for that 65 decision that I'll not appoint a permanent dean and I'll do it only after that?
No.
Where is that?
And there was a delay because we have sent the proposal earlier to government.
Understand. These are two separate and unconnected issues. One, what will be the retiring age, and other requirement of the statute to appoint a dean.
You are a senior law professor, the retirement age is 65 years.
Whoever is a
Now,
so you, because dean retirement is 60, senior most professor retirement is 65. If
So
dean is extended to 65, some of the senior most teachers can
also apply.
okay.
They can also apply.
We can apply, it is apply.
So- So you then you maintain a status quo. Then
That will depend.
if that is the issue, maybe you have some reasoning then you maintain the status quo as on
No, I
today.
don't think it's that's a matter of.
You maintain the status quo, give opportunity to everybody.
Most probably, they will, ever taken a decision of that. Take a status.
But suppose we maintain the status quo, this man will retire at the age of 60.
Both of them has to retire on 60, but what happens? If when they address the issue, there is qualifications are laid down by under the rules by the ICA and Indian Council of Agriculture. Now, some people are not qualifying normally under the ICA, but I like them for some many other reasons. But if they come for selection, they may not fit into the ICA qualification that the virtual is on.
No, Mr. What I am asking, what Mr. Kotoki is saying, that there is a likelihood of the retirement age being increased to 65 for a dean. For senior professors, it is already 65. This is what he says, if I am not wrongly understood. So, they want to make this arrangement to invoke 4.2 to wait and see that if dean retirement is also increased to 65, then some of those senior professors will be eligible. But without waiting, if I go for the advertisement right now, those above 60 and below 65 senior professors will be ousted. So I want to also give them an opportunity. Possibly this is what. Now, in this circumstance, instead of allowing a head, if I maintain an order of status quo, then this petitioner will continue beyond his retirement age. But that will again be impossible. Means it will
One
be
will continue, one will not continue. Let them first make an advertisement. Because your logic will look at the first they have to make an advertisement so that people who were as far after taking the qualifications to be required from ICA.
so out of the 2 persons, one will continue,
One will continue.
but one will retire.
One will. So what
But if I order a status quo, the one will retire, he will also continue by virtue of the court status quo order.
file an application for alternate because
Otherwise, I was ready to pass that order. But what will happen on the day of his retirement? By virtue of the court order, he will continue. But otherwise, for government service, he has to retire. That will be, that's why I'm asking, is there any provision for any extension?
No.
for the statute, I don't mandate a provision for it. But it's a discussion with statistics are given to you.
Can the court, is there any situation where the court can extend? No, impliedly extend, because moment I issue a status quo, it will be impliedly extended. Because status quo means as on today, the man is dean. And if I order a status quo, he'll continue to be a dean even after his date of retirement. So it will be an implied extension. Is there any provision under anywhere where 226 code in a given justified situation can also extend?
Because in the subject to your lordship, that's a very important. The act says that it is mandatory to have a dean. The principal act. And they say that all the faculty, there will be faculties will be headed by a dean under the different departments, and it will be the head will be the dean. Then there is a mandatory provision saying that these are the stringent provision for selection of it.
Understand?
Here the age guideline is not there. The dean is a officer of the
And dean, what is the retirement age of a dean?
60 years.
From where do you get it? Where is the provision?
I am not 65.
Appointment order, your document can you say?
No. Where is the provision that a person appointed a dean will retire at the age of 60?
Because officer in the statute, my lord, I have.
Where is it? Which page?
I've already seen.
62. Because so definitely not 60, otherwise the man would not have it in service.
Now I got
85, my lord, 85 is there, my lord.
Because Mr. Kotoki, in some of the services, although there is a retirement age, but if the person is appointed to a particular post, then that original retirement age may not be applicable any longer. It will go by the virtue of the new appointment.
The appointment order itself says for a period of 5 years or in the age of superannuation, whichever is high.
So superannuation was otherwise 60 years.
Now he's 62. He's already.
So you did not do that.
He's 62
Superannuation
now.
as a professor is 65.
And no, our dean,
The legal hospital can is 85.
85. What is the retirement age of a dean?
Yes, as a that is the age of superannuation officer of the university standing of 60 years.
That is again a proposal.
Proposal.
That is yet to come into force.
That's fine.
Age of superannuation officers shall be ordinarily 60 years or may be prescribed by the government of Assam. No, this is the existing 85 left hand side. And dean is a officer, and professors are not officers.
Professors are kind of they are not officers, they are on teaching cadre.
Understand? They are not officers, but dean becomes an officer. So once a professor is appointed as a dean, he becomes an officer. Do we have the basis of the 65? No, we'll take it up tomorrow. Okay, can you produce that? If it is 65, that's why I'm asking. Suppose if dean is 60 by virtue of being an officer, professor is 65 by virtue of being a faculty member, teaching faculty member. So a 59-year-old professor is today appointed as dean. He'll retire at age 60. But had he not been appointed as dean, he would have continued up to 65. 65. So now this person, what was he? Was he a professor?
He was a professor. Then he applied for this. Then got selected
As a dean. So then,
Otherwise also, the tenure for 5 years they have mentioned. After completion of the 5 years period, he again reverts.
so no, now what Mr. Pathak has read out, either 5 years or age of superannuation. Superannuation of the person who is appointed, meaning thereby the professor. So his retirement age is 65. So this person will retire either at 65 or
Completion of tenure.
a completion of 10 years. If the tenure is beyond 65, he'll retire at 65. So then I think we can safely pass a status quo order.
Otherwise also, if the post is tenure post, the person is the professor. If he is appointed at the age of 59 years, after 5 years,
He'll cease to become a dean after 5 years,
after 5 years, he can revert back to the
original professor. But if he is appointed at the age of 61, he'll retire at 65 because his original is 65 and whichever is earlier.
the advertisement is at page 66 as against which I was appointed. The requirement was that I have to be a professor for 5 years.
So it has to be a professor.
Without this,
And where is that one, the appointment, whichever is earlier?
at page 74.
Or he attains the age of superannuation, means he'll age of superannuation as he was prior to being appointed.
Professor at 65.
So 65.
What time is
So if this man is yet to reach 65 and yet to complete 5 years, why do you want to replace him?
That cannot be extended.
No, which tenure?
Tenure as a dean,
Why?
because he has completed 5.
Completed 5 years. So that means if I pass a order of status quo, she will continue as the dean and he will also otherwise would have been in service. Only difficulty was court cannot extend the service tenure, court cannot extend. So you maintain the status quo. If you actually want to, so now he can reapply also. He can reapply because he has the age, he can reapply. Huh. So if he can reapply and professors can also apply, why are you waiting for? Waiting for what? So you said waiting for 65?
Because actually amendment was not made in that act.
No. You said that there is a cabinet proposal that age will be increased to 65. In respect of whom?
Deans have been all officers.
So very well.
That has already been.
No. So why do we have to wait?
No, that notification has to be issued by the government.
Understand which page is the notification?
The notification has not come. The last cabinet meeting it was.
Suppose the age of dean is at a future date extended to 65. Now it is tenure of 5 years or your date of otherwise retirement, whichever is earlier. Now, irrespective of 5 years date of retirement, you want to make it 65. Make it. So why do you have to wait? Suppose now you hold a selection. Any person after this due procedure is appointed as a dean. From that day, he will be governed by that one. Maximum is 65. Even if a 59-year person is appointed, he will retire at 65. Even if a 62-year-old man is appointed, he will also retire at 65. It's a consistent situation, so you don't have to keep waiting for that.
Actually, they have overborne only. Notification has not come to me, so I cannot say exactly what is the amendment.
So we list it tomorrow. You produce the material, we intend to pass this order that when an interim arrangement is required, instead of invoking 4.2, which is regarding a dean on leave to temporarily act as a leave during that period, instead of invoking that, when you have a regular dean and when there is a proposal of the enhancement to 65, you maintain the status quo with the existing dean. Let continue. At least the existing dean will be a selected person. The other one will be a non-selected person. I think there is a proposition somewhere when there is a requirement of interim arrangement. A selected person is available and a non-selected, preference should be given to the selected. Mr. Sharma, you check up. Maybe in respect of appointment of principal of higher secondary school, this one judgment is there, I think. When you have to compare the two,
Who gets the
between the already selected person gets a preference for the interview.
The person should be a professor. Otherwise,
Otherwise, he can. And this existing dean, he was a professor earlier. So now what will happen? Because he completed tenure of 5 years, he will be reverted to professor. He'll be there, and another person will be made the dean. No, the 4.2 is not selection.
Otherwise, it should be selection.
It should be selection. Selection, they are not no selection.
Then the students also participate because they are in this there also.
Adjourn on the prayer of Mr. P. Kotoki, then counsel for the respondents in the agriculture department to enable the department to produce a copy of the that extension. copy of the document whereby the tenure stroke retirement of a dean would be extended up to 65 years. List tomorrow. Right. Tomorrow will, and we intend to pass an order maintaining a status quo. If that is the reason, that the status quo will be maintained, and this will be better than invoking 4-2, because the 4-2 person will be an unselected person. And this one is, and you try to get that if possible.
The liberty they quickly complete the procedure. So that I also don't want to go if I'm not selected. Let them complete the procedure.
And the interim arrangement shall not preclude them from completing the procedure. We are deciding only on the interim arrangement, whether 4-2 interim arrangement or the present one.
So that the case is pending, therefore we will not take it. We did come. Because the best person should come.
Item 25.
18 or 19.
18, 19. Yes, Mr.
Same order.
Same order. Yes, Mr. Kandava.
Yeah.
Initially accepted this additional science method. Thereafter, once Tisha left the school in the year 2010, he was the science method. So petitioner was upgraded. And his name was, he is the only being science teacher now. His name has been recommended.
Reading my item number 20.
20.
Item 17.
Acha. Sorry.
Now his name has been recommended by the district school committee as science teacher. But the district school committee that is providing in 77, he says that his name does not appear in the guide up to 2014, 15. So his name started cannot be 47. Now, when in that method, we have referred to 56. 56 method.
Yeah. Please continue. Page 56. What is it?
56, the district education officer already corrected his name for the year for the year 2019. And
Acha. Reason for rejection is in the dice data of 2000.
up to 2014-15, my name is not there.
It is not there.
Not there.
And after that, the district officer, he had corrected it.
Corrected.
And he had
He had sent it to the mission director also. Mission director written a letter to the director also.
director, who's director? So now who will correct it?
Now, my God, as per they have filed immediately saying that now the
And that's why I'm asking the question. Who is going to correct it?
but they have not taken this to the newspaper.
No, but yesterday in another matter, somebody made some submission that NEPA has a system of locking with a window of 3 months, 3 months over, then you lock. And this lock cannot be broken. I think this is somebody's stand yesterday.
In my Mr.
Maybe, but this was the stand taken that the lock of the NEPA cannot be broken. So we are helpless that in paper we have corrected it, but we follow only the dice code maintained by NEPA, and NEPA cannot correct it because it is locked.
Here is also by 2 letters they have corrected.
What do you say?
The law said that because the dice database is maintained by the NEPA. And law said here once it is freeze, law said until and unless the NEPA opens it, they have their own password. Law said we cannot incorporate the same of
No, we understand. The problem we have understood. It came yesterday also. What is the solution now? Suppose there is a genuine mistake.
Yes.
Mistake is corrected. And law requires a mistake corrected must be acted upon. Now you cannot act upon because you rely only on the dice data maintained by NEPA. And NEPA is not going to correct it because they have what you today use the word frozen. They have frozen. So where is the answer? Answer will be either you will take note of the contemporary record where corrections have been made and not only rely on NEPA in a given circumstance, or you take up with NEPA, they will correct it. But it cannot be a thing that because the system is maintained by another entity.
That second option that that
You take note of the contemporary record and not what maintained by NEPA.
no, Lordship, that director authorities or the Union of India with Ministry of Education may be made a party, and Lordship and director state authorities to take up the issue of correcting it where in genuine cases with the NEPA authorities, Lordship. Because otherwise it will remain.
Can we have somebody from the central government?
In this case, my lord, from
Mr. Gogoi, I think you also appear for the central government. Can you take note of this issue? You take up with that organization NEPA, what the NEPA? NUPA. You take up with the organization NUPA that all, and what is the arrangement between government of Assam and that NUPA? That they will maintain it. They maintain some computer system. There these data are stored.
we have to, the state authorities have to include all those requirements, Lordship. And thereafter, after each case frozen on September 30th, Lordship.
September 30th, which year?
Lordship, each year.
Each year it is
September 30th is the last day for incorporating
new data. So now 30 is yet to come.
in this case, Lordship, they are now the 15-16 already corrected. 15-16
NEPA has corrected.
yes. Lordship, the application.
NEPA is also corrected.
Yes, Lordship.
Then why don't you act on it?
No, that we can act, but he is requiring that his name should be incorporated of in 2009 and 10, Lordship. Because that is the base for.
No. Has 9 and 10 been corrected?
No, Lordship.
You make an application for correcting 9 and 10. If they correct it, is very good. If they don't correct, then review it. The way 16 was corrected or 14 was corrected, make an application that even 9 also has to be corrected. And your authority will consider it, whether to be corrected or not. Hmm. Page 82. No. This reconsideration different. You make a specific representation, and who is corrects it?
Lordship, since he is clearing for previous year, Lordship,
NUPA cannot correct. NUPA will only maintain records.
Lordship, they are under Ministry of Education Center.
Understand? No. Suppose the correction has to be done. Who will correct? NUPA will correct, or the Assam authority will correct, and then give the information to NEPA.
Will have to correct.
Why?
Because
Who is NEPA? In the full name?
National University for Planning and Administration.
National Institute of Education Planning and Administration.
No. What I have not understood till now, NUPA is an authority who maintains the record provided by the government of Assam.
Yes.
Or NUPA is an authority who had been delegated the responsibility duty of the government of Assam to do all corrections.
So, Lordship, over India, the central government has delegated it.
You know, they understood my question. ultimately these are schools in Assam.
Yes.
Any correction made has to be by the authorities in Assam. Okay, it cannot be somebody else. Now, what is the role of NEPA? The records provided by the authorities in Assam will be maintained by them because they have a system of maintenance, or otherwise the responsibility of the authorities in the government of Assam has been delegated to NEPA, that whatever I am required to do, henceforth you will do it. This arrangement I am unable to understand.
As per my information provided by the SSA, NEPA maintains the data record of each and every school of all
I
over
understand, that's why.
all over India. And where
See, Mr. Chaudhary, suppose in my chamber I have a lot of space. You have a lot of books and material in your chamber. You want me to maintain your files and books. You can have an arrangement with me that all your files, I'll be stacking them properly in my chamber. I'll keep it in a very good, orderly manner. Other one is that these are my files, these are my books, these are the works. Whatever work I have to do, I'm delegating it to you. You maintain my files and also do the work on the files. These are two ways you can hand over to another authority. What is the arrangement in the present case? NEPA is entrusted only the responsibility to maintain a file, or the NEPA is also entrusted the duty of doing these corrections, etc. I think this answer is vital. If the answer is that NEPA had been delegated the authority even to make correction, will require him to make an application to NEPA. But if NEPA is only an authority to maintain the records, and the records will be dealt with by the authority in Assam, then he'll make the application to that authority. I think this is more necessary. Yesterday also the same thing came up in another matter.
Global system.
The respondents in the SSA to inform the court as to what is the nature of the arrangement with NEPA. That is, whether the NEPA is entrusted only to maintain the records of the DIC codes, or the NEPA had been delegated the responsibility to even deal with the DIC codes. This come. Both are very safe. I think we have already some convenience here. Same order. Okay. Once we have this information, we'll take a call where you will make that application.
Item 21.
One of the societies for your ownership. Under this society manner, they had opened up a pharmacy college in motherhood. One of our that was running. PCI had granted the permissions, but after that COVID came, we had approached the government for NOC, but COVID came in. But PCI allowed us to, Sankardev University allowed us, we were doing. Subsequently, the government, my lord, had paid 45 crore would pay. I just said, they gave us ex post facto concurrence.
Ex post facto concurrence.
So no objection for the last 2 years, 2021, because we were taking students, and 21, 22. Then they said from 22, 23, don't. Stop. The same thing was done with 5 colleges in this section. Here in Madhapur, others somewhere in Nogam, somewhere in Guwahati. These other 4 colleges, they go up. There was an inspection also made for all the colleges. Some deficiencies were found. This 4 colleges, they go and submit an application. That's it. The students are there. Our colleges will go kindly grant. I did not make an application. They were granted from 2020 to 23 onwards regularly, saying that within the next year or 2, you meet up the deficiencies.
So you also want the same treatment?
No, my lord, I came up before this honorable court. This honorable court examined the matter. They said we have much deficiency, we cannot give it given. The other called the additional deficiencies were not good. Now state this honorable court said that you want to go and make an inspection. Now they have made an inspection. Nothing is there. Everything is clear. Only thing that lacuna that they have found is, I thought in a laboratory, shortcoming in laboratory space as laid out. The principal so and so is assured to fulfill within 2 months. In view of the above, the authority may consider to issue Alama PR so and so to pursue PD.
You are appearing for the respondents.
After this also, my lord, they have received this on 14th. Now we are not on the problem for these, my lord. Now what has happened? Sankatet University is now the health university is now conducting these selections for all. And because we don't have an NOC, we will not be a scheduled college there. And my lord, we will be, although we are an affiliated college, we will not be allowed students. This is my view. So they should, my lord, immediately, they have the report, my lord, they should pass it. Pass an NOC in my favor, my lord. Or the other 5 colleges, I don't know what group boys that who they are there. With this, more than this lacunas, they are.
The report, we have just filed an additional affidavit today. Get the report from the
It's on record.
but we have filed it today.
He says it's already on record.
Yes, Lordship. We probably request Mr. Digo appears on leg by the
That's a different reason.
matter may be taken up the after tomorrow if possible.
Tomorrow, I'm not very sure of the after tomorrow because it's
Because my
reported that it's already
I
closed.
understand. I not will direct them because they have a report now. I not will direct them. Let them take a call because they come.
So
and say,
according to you,
Lordship,
after the latest report, the lacunas in the petitioner college
what
is
was going
less than the lacunas of the other 4 colleges, which they allowed to be
on?
completed within 3 years. So you are drawing parity.
I'm
Drawing parity and also Article 14 will come in. That if the same situation you are giving them, why don't you give it to us?
Answer. One. Two, now with the subsequent inspection,
That's what I'm saying. After the subsequent inspection.
What I said was with the first inspection.
Okay. Now after the subsequent,
Inspection, my first inspection, whatever lacunas were
after
there,
the
they have now come down.
after the next one, it's even better now.
It's much better. The only lacuna now that is there is with regard to my lord a checklist. They have said that the laboratory space is small, so that has to be increased. And that much my lord, laboratory space. So the principal has given an undertaking that within 2 months we will.
That's all.
That's
It's in around that.
that's page 100 of the.
We'll take after some time. Let Mr. Gogoi come. But otherwise, Mr. Nair, these pharmacy people, they are also quite relevant for the purpose of this guidelines and
Right. The Pharmacy Council of India has given.
they have given the approval.
No, continuously one of they are agreeing.
They are agreeing.
They are agreeing.
University is
The
agreeing.
affiliation is there. The other 4 colleges are
Then,
operating in this
and
manner.
understand now the government.
Now the government, my lord, is sitting only with regard to my college.
Understand what is the role of the government?
The role of the government is to give an NOC.
NOC
The
for
NOC could be, my lord, no objection certificate to operate. Because the affiliating.
no, that's why we are asking. What is the interstate relation?
But there is nothing written.
One pharmacy council,
Lordship,
second university who is conducting the course,
lordship.
third is the government.
No.
What is the interstate
The
relation
pharmacy
between government
council says-
council and the
Lordship,
university?
The Pharmacy Council says that when you make an application for opening a college, you must have an NOC from the government to set up that. To that extent only.
So government is concerned more with infrastructure.
Infrastructure, whether the land my lord is, Panda land is proper or not, whether there is any other impediment in giving that permission to operate that school there. Yes. None of the business colleges had NOC in 2019.
He is already, he says that there were 5 colleges for which NOC was not granted. In respect of 4 others, they had some deficiency. NOC was granted with a condition that the deficiencies will be filled up within 3 years.
1 year, 1 year.
1 year. This college is not been given the NOC. There was an earlier inspection which says that the lacunas are less than those four college disability submission. And now there is one more report which says that the lacunas have even come down now. So he is trying to make out the case that if you can give NOC to the 4 other colleges having more lacunas than us, why we are discriminated in not giving. This is the submission of Mr. Nair.
That's why so far as the stream of NOC to the other colleges are concerned, with the condition that we are doing 1 year in terms of efficiency or discrimination that we have set up. But to say that they have lesser discrimination, that is not the case. In fact, no record in this or neither there is reading or any record in this.
So why don't you give the NOC that you also complete the lacuna within 1 year?
Here, during the pendency of the liquidation, we have placed the inspection report. Now, thereafter, they have the direction that we must go for a fresh inspection again, because there is a time period in the earlier inspection. So now this is the second report, madam. It appears that it has gone down. So where is
The lacunas are increasing.
No, this one is a lesser. Only 2 or 3 lacunas are there.
Huh.
Compared to
So
the earlier.
these remaining 2 or 3 lacunas, can they be also given 1 year like the other 4 colleges?
But that part, I cannot say this is over. I will request to direct the government to give a final decision. Obviously, there is no considering the fact that compared to the earlier report, this time in the press report, there is only 1 or 2 lacunas.
At page 100, the lacuna is double. I have
No, no.
No, the government, what it is doing,
No, no.
when it went back last time, it said we are not giving. That was the decision taken. The same court had assembly matter to take a decision 22-6.
So you are a little wary of the government.
Because
We can't say.
they are not doing it. Now the college has given an undertaking within 2 months that laboratory thing we will do it. If the
Mr. Gu, you do one thing. You ask the government to file an affidavit. What is your stand in this one? Whether you are willing to give or you are not willing to give. If you are not willing to give, tell us the reason. We'll examine vis-a-vis the materials available.
But in the meantime, that Sankadev, the other colleges will get students. I will be required.
When will that happen?
This is going on. The process is going on within a week. They are going to find ways.
In that case, I can find that by Wednesday.
Today is Tuesday.
Only then.
Today is Tuesday. Today is
Because this
Tuesday.
is the problem. They
No,
have
no.
been- I understand what my is saying.
If his matter becomes infractious by the time this comes, then ultimately the purpose of the litigation
Students that I
will
have
be
taken
served.
in, they are not
Friday,
finding.
let me have the written instruction.
Friday, written
Sure.
Some written instruction.
No, you put it on Thursday, not Friday.
Yeah.
Whether let the government apply its mind that these are the present circumstances, whether it can be given or not given. If not given, why? Okay. What further lacuna remains? And then we'll compare if it cannot be given and the reasons, we'll compare it the other 4 colleges where it was given. If we find that there is a disparity, maybe Article 14 will come in. If there is no disparity, of
So
course.
the other 4 colleges, that might have that inspection reports also be produced before you check. The early inspection.
But will come later.
But that maybe he says that is not being produced at any point.
Produce the complete. And it is stated that the lacunas in the petitioner pharmacy college, as per the latest report, had been reduced to a great extent. It is also stated that in respect of 4 other pharmacy colleges, no objection had been granted by the government in spite of the lacunas being more than the lacunas in respect of the petitioner petitioner pharmacy college. The government to consider the situation and inform the court about any decision that it may take or intend to take regarding the no objection certificate of the, sorry, in view of the latest report, in view of the latest report, which is dated to be dated 14/8/2023. In doing so, the government may also consider whether the present lacunas of the petitioner college is in any manner more or less than the lacunas that existed in respect of the 4 other colleges when they were granted the no objection certificate with the provision to remove the lacunas within the specified period. This day after tomorrow. Or day after tomorrow. Sorry, this order, a copy of the order. You just inform us of the decision. That's all. Yes. One page number 160. This is the impugn order.
Page 156.
Mr. Which come to page 160, that last about 8-9 lines. However, in the decree passed in title suit number 55, name of Khudeza Khatun appears at plaintiff number 6. Okay. Further, Taimuzuddin Mojumdar, who was plaintiff number 6 in that, approached the High Court in seeking for a direction to be appointed. So both are plaintiff number 6 or what? Why? They have the wrong in numbering.
They are subsequent petitioner subsequently by
Understand, we have read that. It is seen petitioner joint party plaintiff in the title suit seeking for appointment. Please to allow the said title by directing to appoint. However, paragraph 3 judgment recorded that Taizuddin Loskor, Khudeza Chowdhury and they pleaded for allowing them to join as plaintiff. The court allowed their petition, but those plaintiffs did not participate. If we allowed by the they prefer their procedure to be appointed, it may mention that petition procedure was technically neither party. Where are the records of the status of 55 at 1990?
CR number, page 88 and 89, Lordship.
No.
Page 88 and 89.
No, they come to that.
Particular and matter whether before the signature was not contested by the
Yeah,
government.
I-
Where the order.
So this was rejected. Who is the petitioner? Who is that? The records of
Already record is there, Lordship.
that is to record is here. Where is it? That is to. No, we will go to the adjustment. So, the records are in a very precarious condition. Little bit of hard touch, the paper may come out. Just take note of this order dated 22/1/1991, and then take note of the plate. See number 6, what is that?
Yes.
If you go to the order sheet before that, order dated 22/1/1991, it says that the application has been filed by Tomizuddin and others. A prayer for improvement allowed, it's something like that. 22/1/1991. Now, having read that, please come to page 161. Page 61 of the red petition, 161 of the red petition. That second sentence, it may be stated here that petitioner Khodeja Khatur Chaudhary was technically neither party in TS 55 1990. Why the secretary thinks so? Because records clearly demonstrate that she was plaintiff number 6.
Madam, there is one order, madam.
No, no.
Since it is second,
Instead of going into this one, that is incorrect. You have seen the records yourself.
yes, another order, madam. Proceed to the next pair, madam. Page 1.
During pendency WPC,
Yes.
Metro moved to SIC. One vacant for finance referred the matter to senior standing counsel. Senior standing counsel opined that no right accrued in favor of senior in pursuant to the judgment of. Yeah, why?
Yes, madam. In fact, madam, the-
Why? No.
I had the occasion to go through the entire record. But it, my madam,
See.
if I remember,
No.
there was an order that madam, the petitioner hearing, madam, no other party in the transaction. But subsequently, madam, she never pursued. So there is an order saying that this order will be applicable.
Where is it in the record? If it is right, it may be right also. Please find out. Where is the order that the judgment and decree will not be applicable to plaintiff number 6?
That's part of the private employment report.
No, that has to be in the title suit also. Got it. What does it say?
In judgment, madam, may I read paragraph 3 of the judgment? By filing petition number 160 of 2016, dated 22/1/1981, Mohammed Taj Hussain Prosper, Khodeja Khatur Chaudhary, Taimuddin Fazulkar, Abdul Razak Gormia, Sirajuddin Gormia, pleaded for allowing them to join as plaintiff. On the same day, the court allowed their petition. But these petitioners afterwards did not participate in the suit. As such, their case has gone on before. That is been recorded. Thereafter, court proceeded for the final. This is for this reason, I have an opinion of that. That a partnership. That a part cannot be.
It cannot be a party. No. Well, hear you. Your entire case is that there is a decree in the 1991 suit requiring you to be appointed. This is your case.
State apart lordship.
So you abandon that.
Lordship, it is a technical term, but the degree was, it is the degree lordship finding is there lordship. It is only in the.
No. In the decree itself, court provided it is not for you. Either you challenge the decree.
Lordship, I am coming lordship, just asking the some background of that lordship. There is a division bench judgment lordship. In that division bench judgment, page 88 lordship. May I kindly read it, lordship? Page 88 lordship, this court directed not to appoint any other person. May I read, lordship?
Sorry.
Page 88 lordship. My petition. There was a repetition. Petition bench order is there lordship. It was started from page 87 lordship. From page 18, it is no part of this court directed not to appoint any other person to the post of education teacher outside the list, and it was further directed that the appointment shall be made till the list is exhausted.
what you have read, that all appointments in future shall be made till the list is accepted,
Exhausted.
exhausted. Mr. Alam, why don't you read the whole sentence?
Lordship, I'm coming.
No. You have read only after the comma.
Lordship,
Read the whole sentence. We are unable to accept the contention.
Lordship.
So court has rejected it.
No, Lordship, last time coming last also, that paragraph I read.
We accordingly direct the petitioner shall be entitled to an order passed in civil rule 21690 batch. If, in other words, petitioner shall be appointed in the future vacant post, we direct all. Now, who is the petitioner in this case?
Lordship,
Sikharani.
Lordship, I'm coming. That's
No, you are also coming, we are also going, Mr. Alam. So this is order of Sikharani.
Lordship.
Court says entitled to an order passed in civil rule 2160.
Lordship.
Where is civil rule 2160? That order of the division bench is in respect of Sikharani,
Lordship.
saying that she will be also entitled to the order passed in civil rule 2160. Where is the order of 2160?
Yes, I am also coming, Lordship. Downline, Lordship, from that. Last year, we are unable to accept the as per the direction of the above statement of the bench. All appointments in future shall be made in the list is exhausted in the same paragraph. The same page, Lordship. Then, Lordship, we accordingly directed the petitioner shall be appointed to the Lawrence of bench. And the bench, in other words, the petitioner shall
Sorry.
be appointed in future.
We further direct that all future vacancies in the district of Hailakandi shall be made only from the said select list. So you are trying on this one. Yes, Mr. Google.
And just I'm coming, Lordship, with all that said. I'm please trying to.
No, please come. We take note of this one.
Already, Lordship, moving since
No,
long back, Lordship, been a round of litigation.
No, now,
Lordship, right, Lordship.
what more you want to say?
Then, Lordship, page 99, Lordship. Lordship, my name, all Shamsul Rashko Tajidin, Abdul Jacobiya Tajidin Rashko, they were directed to the Deputy Commissioner.
Honorable High Court's order passed in contempt case 161
Lordship, there was a
and title suit 55.
Lordship.
The same title suit, that one.
Lordship.
Hmm.
There was a contempt Lordship against the petition Lordship for getting appointment. Those while they have get others were getting appointment. Up to 1 to 5 Lordship, my name is, so they don't have to choose. Then Lordship, next page. Lordship, it was directed for SIU, SLC approval. That is filing review application. Mandate entire paragraph by appointing the following petitioners as school teachers against the existing available vacancies at your disposal. Since the limitation for filing review application has already expired long back as stated in your letter, and the quantum proceeding has been pending in this honorable court regarding the same matter. This is also as per the advice of the government. So all the names are there. Then next page 100 Lordship. For SLC approval Lordship. For SLC approval Lordship, these 5 persons were given the name and another person was identified face Lordship.
Where is it?
That is Almota Chudri. All 5, that is earlier list, all 5 is there, but in serial number 6, my name is not there, Lordship. One Almota Chudri, whose name appeared at selection number, the selection position of 379. Below me, Lordship. Where appointed. SLC has given approval. Then, Lordship,
So have you made Azmat Ali a respondent?
no, Lordship.
So now I think we should cancel Azmat Ali and give it to you.
I am also.
If you go by page 100.
I am coming also back also, Lordship. Others were also there. Then all process were made, Lordship. Then Lordship page 114, Lordship.
Is the name of Azmat Ali there in Mr. Gogoi?
In the select
Where is the
list,
record? Record of that? Here,
INS
this one.
select list. Page 370.
So where is that record? That is should record. Give it back. Yes, Mr. Mujumdar.
Lordship, 379. In the select list,
Page number.
page, 37, page 45, Lordship. I will enter the select list.
How many times this matter was heard?
So many times, Lordship.
Because all flexing here and there.
Lordship,
About that, we said you want to get confusion.
Lordship. Next time,
Page number 104.
prior to that 104, my name kindly mention Lordship select this page 42.
Page number.
Page
No,
number.
no, okay, we understand it is there. Now,
My
what
case is only that Lordship with all respect.
one division bench says, till the select list exhausted, no other appointment. And two, page 104, and 99, your name is there. 100, your name is removed, somebody else's name comes in.
Apart from
And
that,
Azmat Ali has been appointed in a week.
apart from that, Lordship, 236, up to the time Gogoi was also appointed. My below
So-
just 235.
Can we ask Mr. Gogoi now?
Sorry, sir. Lordship.
I think we have completed.
Sorry, sir.
Or you want to say something more?
Just
More?
Lordship, Lordship, I am not on that Lordship. And their affidavit also, they have admitted that below me, pay me, 162, paragraph 4. Sorry, Lordship, that's,
No, you can continue.
now Lordship, that's I am giving the.
No, what we have already said
Lordship,
requires us to consider something.
Lordship,
So we want to consider that.
Lordship, Lordship.
And if you want to say something
No,
more,
Lordship,
you
Lordship,
are.
I am not on Lordship.
Because sometimes what happens is, if you say more,
No, Lordship, Lordship.
that
I am
more
not-
may sometimes come against you what you have already
Lordship,
said.
Lordship, I am not on that Lordship.
But this is good. Mr. Gogoi, it relies on two things. Division bench says, right here only, we further direct that all future vacancies in the district of Hyderabad shall be made only from the said select list. Said select list, we understand his name appears. And no fresh candidate shall be appointed till the list is exhausted. We don't know how justified this order is, but the order remains. So he claims that by virtue of this order, I'm there, whether or not in the title suit or not. I come by virtue of the division bench. And there is no appeal or anything against the division bench. Then division bench thing was processed. Okay. And the title suit was also taken note of. If you come to page 99, 6 people, Sama is the plaintiff number 1, Taimur, Simadullah, all of them are there, Tajuddin and Khudeja. But when it goes to the stage of obtaining approval of SLAC, the name of Khudeja disappears and Azmat Ali Chaudhary comes in. This is an illegality. Then your other arguments will not be available.
Because it was division bench.
Firstly, division bench says, till this list is exhausted, you appoint. There the name of the petitioner is there. It was processed further. From the director to the deputy inspector, her name is there. But when it goes from the undersecretary to the deputy director for SLEC, her name disappears and name of Azmat comes in. There, I think somebody done some illegality.
Page 99, the letter of 7/5/1997. SLC is of 2001.
In between, somebody done an illegality, take out the name of Khudeza and bring in Azmat. And Azmat must have got an undue benefit. If you want, you take action against Azmat. Issue notice, remove him. And in his place, Khudeza should come in. If you have acted upon by the same process. I think you are for the education. I think you have to explain how Azmat comes in place of Khudeza. And during that period of time, especially around this late 90s and this one, I have come across a number of instances where a legitimate process is going on in respect of some people. All of a sudden, you find one man is taken out from that process and another person from nowhere is brought in. And the person from nowhere ultimately gets the benefit. This is not the only instance. So at that stage, somebody must have been working in the department. It's like changing the bogie of a train. A train is going at 5 bogies. All of a sudden, you take out one and substitute another one, and the train goes and reaches the destination. The respondents in the education department to explain as to why, in spite of the order of the division bench at page 89 of the petition, providing that all future vacancies in the district of Hailakandi shall be made only from the select list and no fresh candidate shall be appointed till the list is exhausted, had not been followed in respect of the writ petition of Khudeza Khatun, inasmuch as it is an admitted position that her name also appeared in the select list concerned. Further, it is noticed that by the communication dated 7/5/1997 from the director to the deputy inspector, the name of the petitioner Khudeza Khatun Chaudhary was also included along with others for being processed for appointment. But in a later communication dated 33/2001 from the undersecretary in the education department to the deputy inspector of school Hailakandi, the name of Khudeza Khatun Chaudhary had been taken out and replaced by Azmat Ali Chaudhary. Ultimately, it is stated that the 6 candidates processed by the communication of 1997, apart from Khudeza Khatun, had been appointed, and the appointment had also been meted in favor of Azmat Ali Chaudhary, who substituted Khudeza Khatun in the communication of 2011. The aforesaid situation be explained by the education department and also submit as to why it should not be construed that an illegality had taken place by taking out the name of Khudeza Khatun from the candidates processed for appointment and substituted by another person, namely Azmat Ali Chaudhary, whose name did not appear earlier. Azmat is there. So you give it to Azmat also, but not take out Khudeza. When do you want, Mr. Puka? A copy of the order to Mr. Puka. Dates will be arranged there. Yes, next time.
23-24.
Not on record. Set 2 affidavits were not. You have received it. It's stated that by the petitioner. Your name, please. It's stated by Mr. K. Sinha, like on the petitioner, that 2 affidavits have been filed. which is not on record, just again along with the few. You want to give any reply to them? Not required. You want to give reply? When do you want? Take it.
For hearing 25 to 29.
Then the whole series will have to go. Who appears for petitioners? You appear. Anybody for a petitioner? So he wants adjournment. We grant it. But they are objecting. See, we are ready to grant adjournment, but they are objecting. You take it up with them. I don't know. You take your call amongst yourself. If you want, we are ready to hear you. If it has to be adjourned, give it. 2 minutes. Who is your senior? Who is your senior? Mr. BD Kaur. Where is he?
He's on his way.
His way.
Yes.
From?
He just went to the washroom.
Okay, within the court premises.
Not similar to other matters.
28. Can we, should we separate it? But again, Mr. Saikya is not there. RC Saikya. So no, if you want to separate, we can segregate, but we have to tell the other side also. Yes, we'll hear you. What are these matters, Mr. Mukhtar? You must be knowing.
Other matters are that seniority matters.
Regarding what? Regarding what?
Regarding the joining back.
In some college? Mukalmua? That
That man Lokpal on this case.
Is-
From 2001, this case also I was waiting to do it for last few days. On the last occasion also they took time saying that the senior provincial minister, Mr. Mahmood was busy. They said that they have given another calls. But we have
No,
also
I think Mr. Mohanto is there. You say Mr. KK was against yesterday or something like that.
but already quite clear is whether this matter is of 2014. What has happened in this case? I was the geography teacher. I was the third most person, and my date of appointment was 2000.
Mr. Kaur, just are you to decide the repetitions individually or as a group?
Individual.
There will be one judgment or there will
No,
be
separate.
several judgments.
Separate. In my case,
So-
only in regard to the
So which is your matter? 27.
item 27. Very small issue is.
And which and 26 is also your matter. Item 26 is also yours.
But,
Are 26 and 27 connected?
no.
Then let us hear 26 today
That's
because he is having for 27.
Mohammed Azhar on the last occasion they took time, but I can give a brief synopsis.
No, what I'm saying, if item 26 and 27 are to be separately decided, and Mr. Mohanto is having difficulty for item 27,
But
we can hear
26,
26
I think,
today.
madam, there is no live issue. I have also not looked because 26, your lordship has already passed the judgment, giving all.
Noor Sahed Ali,
Yes. Then that matter went to another. Then the government said that we will file a review before your lordship, but they said ultimately now they said that we will not file a review before the lordship. We will contest that review. So Noor Sahed, I think your lordship can come. Your lordship.
Noor Sahed is still in appeal. Appeal not decided.
I will not decide. Another
No, that's what he said. Yeah, appeal is pending.
It is pending in the, now the education development is constituted for the registration matter also.
This is for provincialization, these cases.
So, no, see,
No, somebody said seniority.
No, Moonside was a happened.
in respect of Musa,
That is provincialization.
so that matter was question how it is taken by the education plan, which is constituted by the.
No, what are subject to what I'm saying. Against the order of Moonside, they went to appeal. The division bench gave an option, the learned advocate general appeared and said that we'll file a review for the London signature. We waited for almost 1 year to file the review. They did not file a review. We filed a contempt petition. Now they are saying that they have asked the Honorable Chief Justice to constitute a bench and all. I am not aware of it because whenever the matter comes before the division bench, the other side is taking time. So that constitution of the division bench, especially for Moonside case, I have
No, that is not the issue. Constitution of division bench for a pertaining to the issue regarding provincialization matters. The appeal which was pending before a matter of division bench.
That appeal will also be listed in that bench.
Particular bench. So already, my lord, Chief Justice has directed us to get them into the registry. We have placed over the registry. And next sitting, we will send the special division bench.
So that will take its own course. So we are not concerned. Now, present matters, what do we do?
Present matter regarding, some matters regarding dispute hearing, not a seniority. Seniority.
And what Mr. Kaur had submitted, that you need separate judgments for the separate writ petitions. If that is so, let us start hearing one by one. Decision in the first writ petition will not have any effect on the second one. We'll go one by one on its own facts. So let's start with item 25 then. 25, Mr. Mohta doesn't appear. Who appears in item 25? You also want accommodation, why? But he is expressing urgency.
I'm frustrated by all this.
But your case, Mr. Kaur, your matter we can take up because Mr. Mohta is raising.
They should have.
So, Mr. Mohta, when will you be ready? On which day?
Any day convenient, my last location was where.
12/4. Basically, 12, 6, no, it's already 4. 19. Item 27 of Vikibo. Mr. How do you write your name? KM. Mr. KM Mohantal and counsel states that Mr. KK Mohantal and senior counsel have been recently engaged correspondent before and therefore would require some time to prepare the matter. Mr. B.D. Kaur and senior counsel for the petitioner objects to the same, saying that the matter express some word has to be put. Mr. B.D. Kaur and senior counsel for the petitioner is of the view that the matter requires an urgent hearing, considering the prayer of both the parties. List on switch. This is item 27. To be 27 to be listed separately. Because there is no connection with anything else. Separate. 25, what you see? Sorry. To be listed separately. Yes, what is your submission in 25? Sorry. A little louder. And your name, please. Mr. S. Sarkar and counsel appearing for the petitioner in item 25. Please that the matter be not taken up today and another date be fixed. Mr. Mukhtar, you are appearing. No, 25, no one appears. 25, you appearing. When do you want 25? Adjournment allowed, matter to be listed again.
Yes, sir.
You're for which item?
Item number 25, it has already become in terms of only 20.
But he is appearing for petitioner. He will say, for whom do you appear?
The petitioner.
But he is saying he appears for the petitioner. We can entertain only one learned counsel. You choose between the two and make your submission.
Automated password in that fact number 20.
We have filed ILOs. We have filed ILOs. But 26 I think is already disposed of and it is infractions act now because of the options.
That will, no, let's settle 25 now. What is your name? BJP.
On behalf of Mr. SP.
No, we cannot close the petition if you do not appear. Wait, let me take care. If Mr. ask Mr. Chaudhary to make that submission. And what is IA 172? Who filed it? MAI Hussain K. Chaudhary AR Mia. You are there. For what purpose IA is filed? You don't know. And then another IA, MAI Hussain AR Mia. So according to you, we don't not required to decide item 25.
We are not listening.
Ask Mr. SP Chaudhary, D. Das, S. K. Roy, K. Bachcha, A. D. K. Vishwakarma, R. Sinha. Sorry. No, if they don't want to press with their petition, we don't have to decide anything. We'll simply close the petition. I will also be closed because the repetition will not survive anymore. Does any of the learned council appear? Is any of the learned council appear? So it did not impede if the writ is closed. Do any of these learned council, are they available?
If I remember correctly, this IA was filed in respect of an FIR registered against Lokman Ali. And that against that, he had also filed a criminal petition for passing of.
So therefore,
I think this matter has also been.
No, an interlocutory application will be closed on its own if the writ petition is closed. So we did not go into those questions.
She is paying on behalf of Mr.
But it's difficult to close if the learned counsel is not on record. It is stated by MS B. Devi, learned counsel appearing for the writ petitioner, item 25, that the matter does not require any further adjudication. But however, as the learned counsel who are on record in the writ petition are not available, an adjournment is sought for. Pray along this counsel. So 25 or 26.
I think this is a becoming infrastructure.
Are you sure? Or you want to go through it? We don't mind closing it, but
You know, should close it unnecessarily. This vertical list and 26 for the that's it. Because the main judgment your lordship has passed, granting all the relief to.
so can I can close?
Yes.
Mr. B.D. Kaur, learned senior counsel for the writ petitioner 26 states that because of the subsequent circumstances, no further adjudication is required in this writ petition. In view of such statement, writ petition stands closed. Any liberty? No.
Your lordship keep it the liberty because.
However, liberty remains if the occasion would arise for the petitioner to again re-agitate the issue raised. And now 27, gone, 28. But who appears? RC Saikia, Khatonia, Saikia, Day.
Provincialized matter.
But we cannot close on behalf of a respondent. That will not be very good. None appears for the petitioners when the matter is called. List again on so and so. However, Mr. S.K. Mukhtar, learned counsel for the respondent number 6 states that we can infractious in as much as
She has been already provincialized.
Who?
Yes. Petitioner.
in as much as the petitioner Gita Rabha had already been provincialized as
Assistant professor tutor.
assistant professor tutor in the college concerned. List again for appropriate orders. Now 29. Again a speech order. 29. adjourn on the prayer of MS B. Devi. B. Devi, Land Council appealing for a petitioner to be listed again. Also. And all these matters will be listed separately.
Yeah.
No more. Okay, 19.